My please start. Lordship, item number 39. It's a landlord tenant matter. So both the respondent expired, Lordship. So I may be allowed to file substitution application within 1 week. Lordship.
We'll see when the matter reaches.
Yes, Lordship, that is true. That is true. I have also informed respected counsel, Mr. S.C. Coyle, sir. S.C. Coyle, sir, will inform, furnish detail of legal error today itself.
So let the matter reach.
Hello.
May it please the Lordship. Lordship, I beg to mention for listing of two connected CRP, Lordship. It's an eviction matter, Lordship. One is
Go to another bench. Today only there's another bench. No?
Supplementary list, item 43 for motion.
Lordship. Lordship, here the issue is, my lord, whether WS can be accepted in a commercial suit after 120 days or not. I have found some judgments of Bombay High Court as well as from other high courts. In these cases, considering the, my lord, Supreme Court judgment, my lord, the WS was accepted, my lord.
Tell me one thing.
Yes, my lord.
This was a commercial suit.
Yes.
If it was a commercial suit, whether the provisions of the commercial suit which is required for pre-AR was adhered to pre-litigation
12A.
huh?
12A of the commercial code set. Lordship is referring 12A of the commercial code set. Pre-institution mediation. In my case, my lord, it was first went to the pre-institution mediation. Thereafter, it was filed before the Munsif court as a money suit. Subsequently, it was transferred to the commercial court, and then I got notice from the court of the commercial court, and I appeared. I sought for time for furnishing me the documents. While furnishing the documents, 8 months time have elapsed. Thereafter, after filing of the documents, when the suit was proceeded ex parte, I defaulted and suit was proceeded ex parte on that very day. 120 days for filing the WS was not completed. And thereafter, court fixed the next date on November for ex parte evidence. On that very day, I filed my WS along with an application under Order 9, Rule 7 for setting aside the ex parte order and to accept my written statement.
That I understand.
Yes.
So who passed that order? Senior division.
Senior division.
So that is the commercial court.
commercial court.
When did you receive your documents?
Documents though they have submitted on 35/2024. But actually I received on 15/7/2024. What had happened actually on 35/2024, they have submitted belatedly. The plaintiff submitted the documents before the court belated.
Where have you mentioned in your petition?
That I have not mentioned.
Then,
But my lord, if I consider from 35/2024 also, then also my lord, when the suit was proceeded ex parte, 120 days was not found. Because my lord, from the date of 35/2024, the period of 120 days would expire on 27/9/2024.
let us see that 19/9/2024 order.
My lord,
19/9/2024 order.
order. Page 30. Plaintiff is represented, defendants are absent without steps. As such, the instant suit shall proceed ex parte against the defendants. Fixed 29/11/2024 for ex parte evidence.
So let us make this your case. Whether you have pleaded or not, I don't know. That a perusal of Order 9 Rule 7 say the court shall proceed ex parte if the defendant is not represented. Taking into account the judgment of Sangram Singh,
Yes.
proceeding ex parte is required only for that date.
Yes.
And thereupon, a defendant can very well appear on any other date.
Yes.
But if he shows good reasons, the suit goes back to the stage of 19/9/2024. And if it goes back to the stage of 19/9/2024, it is within the period of 120. Is it your case?
Yes.
Where is it?
My lord, I have stated in my grounds, my lord, of this
me.
civil revision petition.
Where is your ground to the
Ground 4 and 5.
No. This is not a ground.
My lord is my lord 5, my lord.
This is on principles of natural justice. This is no business out there.
No, my lord, what I am, my lord, being ground number 5. I have said, my lord, the plaintiff submitted the documents only on 35/2024, and the same were received by the defendant on 15/7/2024. Consequently, the 120-day period would expire on 12/11/2024. Despite this, the learned trial court by its order dated 1990 to record proceeded ex parte against the defendants, that too for a single default, and directly fixed the matter for ex parte evidence on 29/11/2024, thereby prematurely and unjustifiably curtailing the defendants' right to file their written
No, no. This is not your case. If this is your case, I can't help you.
My lord, the judgment which I have relied, my lord, in three judgments, my lord, in
No,
one,
those judgments, one of them directly goes against you. And the second judgment is not on commercial. First judgment is on pre-litigation. That is why I asked.
no, my lord, that was pre-litigation. But there it has been, my lord, referred that if any, anything, my lord, any lapse or any fault on the part of on the procedural part of the court, in that situation, court can extend the period of 120 days. And here, in my case, my lord, if we,
There is no mistake. In this case, there is no mistake.
if the, my lord, order was passed on, my lord, 27/9, my lord, and I did not file on that day, then matter would be different. But in my case, the proceeding ex parte on 19/9.
If you say make that submission, again it goes against it in view of the division bench, in view of the Supreme Court judgment. You cannot get away of it. You have to use the words in order 9, rule 9, rule 7. See orders 9, rule 7. Yes, read it. Read it.
Procedure where defendant appears on day of adjourned hearing and assigns good cause for previous non-appearance. Where the court has adjourned the hearing of the suit ex parte. When the court adjourned the hearing of the suit ex parte, well, that day was not fixed for, well, hearing. Well. That day was not fixed for hearing. Well. Ex parte.
No. Then you have to go to order 9, rule 6A. Now here the court has to proceed. Now kindly come to order 9, rule 7.
Yes. Where the court has adjourned the hearing of the suit ex parte and the defendant at or before such hearing appears and assigns good cause for his previous non-appearance, he may, upon such terms as the court directs as to costs or otherwise, be heard in answer to the suit as if he had appeared on the day fixed for his appearance.
So therefore, what is your argument, which I'll put it out there in writing, is that goes back to the stage of 19/9/2024.
Yes.
And if 19/9/2024 the suit goes back, it is still within the period of limitation.
Yes.
Because 120 days is not over on 19/9/2024. So the problem which is there with this court, the judgment of the Supreme Court, which makes it 120 days, is being duly taken care of. This will be by way of a doctrine of eclipse. You take away the period from 19/9/2024 till date. And thereby, your written statement can be accepted, having been filed, if I allow order 9, rule 7, and bring it within that period. That is the only way out.
My lord, in my case, my lord, the learned trial court has allowed my petition.
No,
Order 9, rule 7 petition was allowed.
no. Order 9, rule 7 petition was not allowed, actually. See, if you see, go to Sangram Singh's judgment. Sangram Singh's judgment categorically say that a defendant can always appear at any other stage.
Yeah.
What the learned trial court say, then let him appear. That is not the essence of order 9, rule 7. Order 9 Rule 7 is putting you back, your clock back to that stage. This is the wording in Sangram Singh.
There are 33. my lord. My lord, what in Sangram Singh, my lord, it has been, my lord, what those consequences should be in given case is for the court in the exercise of its judicial discretion to determine. No hard and fast rule can be laid down. In some cases, an order awarding cost to the plaintiff would meet the ends of justice. An adjournment can be granted or a written statement can be considered on the spot and issues frame. In other cases, the ends of justice may call for more drastic action. My
You
lord,
have
here, my
read-
lord,
have you
admittedly,
read Sangram Singh properly?
my lord,
Have you read the entire judgment of Sangram Singh properly or not?
my
No.
lord, I have read.
You have read in pieces, bits and pieces. If you see the judgment, it categorically mentions that the clock is being put to that position on the date on which the court proceeded ex parte. Now, if you put the clock back from that position to that position, that is on 19/9, isn't it within the period of limitation?
Yes,
But that is not your case in your petition. That is what I am saying.
my lord, whatever I have formulated here in my case, my lord, my lord, as per limited understanding, my lord.
There is no
Okay,
limited
once, my lord-
understanding. You are a fine counsel. There cannot be a limited understanding.
Once and my lord, my application was under order 9 rule 7. And my lord, that petition was allowed.
Lekho. How much is he asking from you?
Oh, my lord, 8 lakhs. my lord. For 4 invoice, my lord, 3 lakhs 86,000,
8 lakhs.
8 lakhs, my lord, I'm coming to exact figure, my lord. Page 24, my lord, paragraph 13. my lord. Total amount 8 lakhs 4,011.
Okay. Get ready with 35,000 cost next time when I take it up. 35,000 cost.
But admittedly, my lord, it was not fault of the, my lord.
You pay.
It was my fault.
Your fault.
My lord, why I'm saying so, my lord, on that day, my lord, that it was not fixed for filing the, my lord, though it was filing for WS, my lord, but it was due to my non-appearance, my lord.
So you get ready with 35,000. Issue notice making it returnable on 6th of June 2025. Steps be taken upon the respondent numbers 1, 2, and 3 by way of registered as well as usual during the course of the day. In addition to that, the petitioner is directed to take steps upon the respondent numbers 1, 2, and 3 by way of Dusty, routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein has approached this, the petitioner herein has invoked the supervisory jurisdiction of the court, challenging the order dated 21/2/2025, by which the application filed under Order 9 Rule 7 of the Code of Civil Procedure 1908, for short the code, was rejected, and thereby not permitting the petitioner to file the written statement. The learned counsel appearing on behalf of the petitioner drew the attention of this court to the order dated 19/9/2024, whereby the court had decided to proceed ex parte against the petitioner and fix the matter for ex parte evidence. The learned counsel further submitted that thereupon the petitioner filed an application under Order 9, Rule 9, or Rule 7 of the Code, and also filed a written statement on 29/11/2024. It is a submission, specific subcategorical submission of the learned counsel appearing on behalf of the petitioner that the provision of Order 9, Rule 7, if read, the provision of Order 9, Rule 7 would show, a reading of provision of Order 9, Rule 7 would show that if the defendant who was absent on the previous date assigns good cause, the suit would relegate back to the stage the date on which the court had decided to proceed ex parte against the defendant. First, the learned counsel submits that due good cause was shown, and which was also accepted by the learned trial court. But the learned trial court failed to appreciate that with the good cause being shown, the learned trial court ought to have relegated the suit or put the clock back to the date that is 19/9/2024. And if that date is being taken into consideration, the filing of written statement is within the period of 120 days. Taking into account the said submission, it is the opinion of this court that the petitioner has been able to make a prima facie case for stay of the further proceedings of title suit number proceedings of commercial suit number 13/2022 pending before the civil judge, learned court of the civil judge senior division number 3 Kamrup Metro at Guwahati. Accordingly, the further proceedings of commercial suit number 13/2022 pending before the court of the learned civil judge senior division number 3 Kamrup Metro at Guwahati shall remain stayed till the next date.
Obliged.
Thusly, 35,000.
Obliged.
For admission, item 1.
Yes, what is this?
Lordship, the petitioner plaintiff instituted a suit against the defendant number 1 to 4. In the defendant number 1 contested the suit by filing written statement, subsequently filed the counterclaim also. As against the counterclaim, we could not file our written statement because of many certain things, and the claim was closed. My submission before the court is
Which
a
order
counterclaim.
are you assailing, Mr. Bhagavati? Which order?
Actually, I am assailing, there are 3 orders, order 6. At page 48, annexure 5. as well as at page 53, annexure 8.
Then
Annexure 8 at page 53.
Then,
That's all, Lordship. That's all. My submission is that in the counterclaim, the defendant number one also implicated the son of the plaintiff. No notice was issued to him. Because there was certain allegations were made against him also. But therefore, at least he has the right to, because he is a party to that counterclaim,
who?
son of the plaintiff petitioner.
So he has been, defendant number one has made him a counterclaim
In the counterclaim.
against the plaintiff number four.
Plaintiff, no. The plaintiff instituted a suit as against defendant number 1 to 4. One contested the suit by filing written statement, subsequently filed his counterclaim. In the counterclaim, plaintiff, the defendant number 1 also made party to the plaintiff's son.
How?
I do not know.
How you don't know, that is your lookout. But the question is how?
That is why, because there is certain allegations made against him, because some amount to be shown to be transferred in his account by of. So that is why. So no notice was issued to him also.
What is the suit for?
Suit for cancellation of his unregistered agreement. On the basis of the unregistered agreement, the plaintiff
And what is the written statement for, counterclaim for?
counterclaim for that transfer, cancel, honoring that, what is that said agreement and transferring that vehicle in his name.
Hmm?
There was an agreement, sold to be agreement, alleged agreement is on the basis of for the purpose of transferring a vehicle, which was hypothecated to defendant number 4.
Where is the counterclaim?
At page,
37. 37, your lordship.
at the next,
37, your lordship.
Page?
37.
36 to 47.
So this is for specific performance.
Lordship.
Huh?
Lordship.
Well-
And fixed court fee only 22 rupees has been paid.
Huh?
Fixed court fee of 22 rupees only have been paid, court fee,
Who has paid?
the counterclaimant,
So what am I going to do with that?
Lordship, of course.
So there is no written statement.
No rejection, because let the pleading be completed.
Huh?
Because
35,000? 35,000.
because, yeah,
You
let it-
failed to pay 700 then,
Lordship,
then again you spent, because of you, the suit got delayed by another 8 months.
Lordship,
And today, if I allow, the suit gets delayed by another 2
Lordship,
years.
that will do.
Cost of 35,000. And your written statement is ready?
It is ready,
Ready?
ready. Because I have been told, because I think it is ready.
I am not concerned. If you don't file it on a particular date on which I have fixed,
Next week,
then in that case, your written statement is gone.
Lordship,
Heard Mr. B.K. Bhagavati, the learned counsel appearing on behalf of the petitioner. And Miss
G. Bora, lordship.
so and so who appears on behalf of the respondent number 1,
1 to 3, your lordship.
1, 2, and 3. The present petition has been filed challenging the orders dated 2012-2022 passed in title suit number 4K/2022 and 36/2023 passed in the same suit by the learned court of the Munsif Koliabor. Whereby the petitioner herein, who is the plaintiff, have been debarred from filing the written statement to the counterclaim filed by the defendant numbers 1, 2, and 3.
no Lordship, only defendant number 1.
By the defendant number 1. The learned counsel appearing on behalf of the petitioner submitted that the petitioner had filed a suit which was registered as title suit number 4 bracket K oblique 2022, seeking a declaration that the unregistered agreement for sale, agreement dated 12/2/2021 is collusive, forged and not binding on the plaintiff, on the petitioner, plaintiff oblique petitioner, and for a decree for permanent injunction. The defendant herein, the defendant number 1, who is the respondent number 1 herein, had filed a written statement along with a counterclaim.
Subsequently,
Had filed a written statement as well as a counterclaim. Pursuant to the filing of the written statement cum counterclaim, the petitioner, on account of not receiving certain documents, could not file the written statement, although the learned trial court had granted due opportunities. And it is under such circumstances, on 20/12/2022, the learned trial court had debarred the petitioner from filing the written statement against the counterclaim. Subsequent thereto, the petitioner again filed an application requesting, seeking an additional opportunity to file the written statement, which was rejected by an order dated 30/6/2023, for which the petitioner has again had, for which the instant proceedings have been filed. The learned counsel appearing on behalf of the petitioner submitted that the petitioner herein, that it is in respect to the same document which the petitioner as plaintiff has sought for declaration, for cancellation. The respondent, the defendant number 1, with the respondent number 1 have sought for specific performance. He submitted that the written statement is ready and can be filed on any date as this court may deem, as this court may so direct. The learned counsel appearing on behalf of the petitioner, respondents numbers 1, 2, and 3 submitted that the petitioner herein have delayed the suit, thereby causing a lot of delayed the suit, have delayed the suit. And the time so fixed for filing of the written statement having expired, this court may not exercise its supervisory jurisdiction. In reply to the said, the learned counsel appearing on behalf of the petitioner further submitted that the petitioner herein is an old lady who is also a widow and suffering from various ailments. And if the petitioner is not being allowed to file the written statement against the counterclaim, serious prejudice would be caused. This court, having given an anxious consideration to the matter, is of the opinion that taking into account that on one hand, the petitioner herein have sought for cancellation of a particular document of the document on the basis in respect to which the defendant number one has sought for specific performance. The completion of the pleadings would be necessary. A further chance can be granted to the petitioner for completion of the pleadings, for filing her pleadings against the counterclaim. This court cannot also be unmindful of the fact that on account of the petitioner, the suit, as well as the counterclaim proceedings have been delayed, for which certain cost has also to be imposed. Considering the above, this court therefore disposes of the instant petition with the following observations and directions. What is the stage of the suit?
It is in already in evidence. Plaintiff's evidence is there.
Plaintiff has adduced evidence.
Only filed evidence.
You have already filed evidence.
It is yet to be cross-examined.
You have cross-examined?
No,
No.
it is not covered.
This court permits the petitioner herein to file the written statement against the counterclaim. Subject to imposition of a cost of rupees 35,000 upon the petitioner. First, the said written statement has to be filed before the learned trial court on or before 4th of June 2025. Along with the filing of the written statement, the cost of rupees 35,000 has to be deposited. Next. Deposited. The learned trial court shall accept the written statement filed against the counterclaim only upon the deposit of rupees 35,000 as directed herein above. Next. The petitioner herein, the respondent numbers 1, 2, and 3 herein, who are the defendant numbers 1, 2, and 3, would be at liberty to file an application for release of the said amount, and the said amount be released, and the learned trial court shall pass appropriate orders. Next. It is categorically observed that if the petitioner fails to file the written statement on or before the next date as fixed above, along with the deposit of rupees 35,000, the learned trial court shall proceed with the suit without further reference to the directions so passed in the present proceedings.
Item 2,
Oh, yes.
Affidavit has not been tagged with the file also. Affidavit has been filed, both the parties. Both the parties shall file affidavit that has not been tagged.
It will not come.
It will become the report.
I gave it. No affidavits have come.
At two, let's agree.
You should have mentioned it. Leave it some other day. Have not been filed.
My lord, except 27 and 28. Except 27 and 28.
Okay, we
Yes,
have
I-
it in the month of June. There's an injunction order,
Yes, yes,
not to construct.
my lord.
Again, that he has come.
Yes,
You can wait till.
the
Let's-
first,
It has been brought to the attention of this court that both the parties have filed affidavits in the matter. However, those affidavits are not on record. List the matter on. On 30,
yes,
35/2025. Whose the registry shall bring on record their.
agree,
May it please, my lords. This is an appeal under section 28 of the Hindu Marriage Act, my lords, against a direction contained in the judgment and decree, my lords. The appellant herein, my lords, had filed a suit seeking divorce, my lords, on grounds of cruelty. The learned trial court, my lords, was pleased to dissolve the marriage, but while considering the quantum of for grant of permanent alimony, my lords, without there being an application, a mandatory application under section 25, and without even ascertaining the inter-se financial positioning of the parties, proceeded to grant an amount of 18 lakh as permanent alimony to the respondent. We are only aggrieved by that determination.
So you agree. What should I do now?
Lords, the requirement, my lord, kindly see section 25
Of
of the Hindu Marriage Act, my lord.
what do you say?
Yes. May I read this, my lord?
Hmm.
Permanent alimony and maintenance, subsection 1. Any court exercising jurisdiction under this act may, at the time of passing any decree or at any time subsequent thereto, on application made to it for the purpose by either the wife or the husband, as the case may be, order the respondent to pay to the applicant for her or his maintenance and suppose such gross sum or such monthly or periodical sum for a term not exceeding the life of the applicant, as having regard to the respondent's own income and other property, if any, the income and other property of the applicant, the conduct of the parties and other circumstances of the case, it may seem to the court to be just, and such payment may be secured if necessary by a charge on the immovable of the respondent. The first requirement, my lords, is a separate application.
So filing of an application is not a bar.
My lord, there is a requirement. If my understanding of this section, my lords, it says on an application. Now the
The
learned-
application can be filed subsequently.
yes, not a bar at all. So, my lords, but there was no application to that effect.
So as
Now-
this court will be exercising the appellate jurisdiction.
Now, my lords,
No, I'm asking,
yes,
because this is an appeal.
Yes.
Being a first appeal, it is not a limited jurisdiction. So I can allow her to file an application also
yes.
and then make it 30. Because she asked for 30.
But taking into account the directions and the mandate as assigned by the Honorable Supreme Court, my lord, there a list of affidavit disclosing the income,
No,
expenditure, and all
I-
that has to be done, my lord.
All these. Thereafter you go to, well, if it is not done, if I give 30 lakhs, and if it is not done, then obviously, because she asked for 30 lakhs and you have given 18.
30 lakhs, my lords, sweeping statement in the WS to the suit. There is no affidavit.
What
to
do you
that
do?
effect. My lords, I run a printing shop, my lords.
Painting?
Printing, photocopying and printing shop, my lords. And my affidavit of assets and income is on record.
Where is it?
My lords, yes. It starts from page 118, my lords. It starts from 1112, my lords. I'm sorry. column 10, my lords will see monthly income is 4,000 rupees. He's not even an income tax assessee, my lord. My lords, page 115. Bottom, my lords, in case of self-employed persons, computer worker, he is an individual. Then page thereafter, my lords, his net income.
Who is PW3?
PW3 is a friend of the petitioner, my lords.
And he says in his evidence that you have rented house?
Yes,
And why you have stated no?
because it is not, my lord. It does not belong to the petitioner, my lord. It belongs to the petitioner's father. And all these, there is an affidavit to that effect, my lords. My annual income, the expenses I incur on a monthly basis, everything is on there on record.
So how much you should pay?
Well, let the court decide, my lord. I'm not shying away from the fact that there might be a payment I would need to
No.
be required to make. But the positioning of the parties, my lords, it cannot be a position where the petitioner, my lord, or the appellant is saddled with an unnecessary financial hardship, my lord.
Hmm.
The direction, my lords, as regards the permanent alimony is concerned, my lords will find that page 152.
So will only admit the appeal. No stay.
Then, my lords,
We'll see when the matter comes up.
so they'll file for execution, my lords. in the meantime.
Fantastic. Let them file. So therefore I asked you how much you should pay.
Well,
You think you should pay.
my lords, I cannot possibly decide, my lord. Let the
Okay.
parties decide, my lord. That the
Sir,
court, my
we
lord, on
will
a application being filed.
Let the parties decide when
My
they.
lords,
Don't worry, I'll take care of that non-filing of the party. Okay, let us admit the appeal and get the jurisdiction. Okay,
my lords,
this is an appeal filed under section
28, my lord.
28(2) of the Hindu Marriage Act 1955 against the judgment and decree dated 14/2/2025 passed in title suit bracket divorce number 72/2023. Full. The instant appeal. By the instant appeal, the appellant herein does not assail the judgment and decree insofar as granting of the divorce,
Or the maintenance for the minor son, my lords.
as well as the maintenance so awarded of an amount of rupees 5,000. The only ground of objection in the instant application appeal is against the granting of permanent alimony of rupees 18 lakhs upon the appellant. That too, without any application being filed seeking permanent alimony as permanent alimony. Full stop. It is the submission of the learned counsel appearing on behalf of the appellant that in terms with section 25 of the Hindu Marriage Act 1955, there is a requirement for filing an application, and since an application, the question of granting permanent alimony would go against the mandate of section 25. Pusto, taking into account the said grounds of objection, the instant appeal is admitted. Call for a records. Steps be taken upon the respondent by way of registered as well as usual. I এখন লিখিব? I is there?
There's no I.
Then
There's no separate I.
what?
There's no I, my lords.
Also, there is no stay.
There is no requirement for it. I was under the impression, my lord.
Huh?
We made a prayer for stay in the appeal itself, my lords.
Oh,
Page 27. my lords.
I will grant you a stay for why? Why will I grant you a stay? Because Mr. Biswajit Chaudhary gives a certificate. No, tell me, let us also be more accustomed with the law.
An oversight on my part.
Huh?
It was an oversight, my lord. I'll maybe allowed to file an IA, my lord. Also,
Item 4,
Why should I give you? You know what to do. I've not said anything.
you're right.
I hope you know the provision under which you are to file an I. Yes, what is this?
This is the MLC appeal, Lordship, preferred by the
Asking for more money?
No, Lordship. This
Why
is
are you
preferred-
challenging?
This is preferred by the insurance company, Lordship. This is preferred by the insurance company.
Why?
One of the insurance company, because two vehicles were involved and there was head-on collision. The learned member took into consideration that fact, that both the vehicles were hit in a head-on collision manner, but entire liability was passed upon only to one insurance company, not to the other insurance company.
Upon you. Why?
See, because the learned court came to a conclusion that the recent negligence part was only by our vehicle, but that was not properly proved. Only based on the FIR given by the claimant. Lordship may come to the interim judgment, Lordship, is number 14, Lordship, para 21. And during cross-examination also, the claimant admitted that there was head-on collision between both the vehicles. And claimants had examined only one witness for death, only herself, no other witness. Although she was the eyewitness, she was traveling in one of the
What
vehicles.
is your evidence?
See, we place the arguments regarding that.
What is your evidence? You have given evidence?
We have not deduced evidence, neither the other company.
Forget about other side. You have given evidence or not? Then how do you bring contributory negligence?
The fact
Contributory negligence has to be pleaded and proved. That is the finding of the learned Supreme Court. I can't help it.
that in the cross-examination that was done by our company, the claimant admitted that there was head-on collision.
There's no quarrel. Merely because there is a head-on collision doesn't mean there's no contributor. May also may not happen. Just for example, a person is going in the right direction. On the other side, your dumper comes out there and just bangs him on the head. Then this is what is the finding.
Is the finding, but no evidence was there.
Evidence is yours. Yours duty. No evidence. Hello, dismiss.
But you may give me another opportunity.
No opportunity.
This based on judgments.
What will insert? I'll give you 6 judgments on this point. You want them? Hello. I'll give you 2, 3 judgments. Recently also give it. I keep all these things for these type of cases to finish up. Unnecessarily 1,10,000 you are fighting out there. And if I admit it, then you have to pay interest. How much?
So we are ready to pay the interest.
Okay, so deposit the entire amount with cost, with interest, and I will allow them to release it. Okay,
We have not placed our state in. We have not Filing an IA for stay.
That is why. That is why if you have not filed an IA for stay, I also know the reason why. I'm dismissing you. You have an IA here. What is that IA for?
Lordship, that was for delay condone. Delay was condoned.
Very good. Now, heard Mr. So-and-so,
SP Sharma.
the learned counsel appearing on behalf of the appellant insurance company. Full stop. The instant appeal is taken up at the stage of Order 41, Rule 11. For deciding as to whether the present appeal can be proceeded with. Full stop. There is an appeal filed under Section 173 of the Motor Vehicles Act 1988, for short, the Act of 1988. Challenging the judgment and decree, judgment and award dated 10/3/2023, passed by the learned Motor Accident Member, Motor Accidents Claims Tribunal, Golaghat, wherein an amount of rupees 1,10,904 along with interest at the rate of 9% per annum have been awarded from the date of filing of the claim petition, that is from 8/9/2017 till its realization. Full stop. The ground of objection which is being taken in the instant appeal is that the learned tribunal had settled the entire liability upon the appellant insurance company, when the present case pertains to a case of head-on collision. And as such, on the face of it, there was contributory negligence. This court finds it very relevant to take note of. That at paragraph number 21 of the impugned judgment and award, the learned trial court tribunal had duly dealt with why the entire liability has been imposed upon the appellant insurance company. Taking into account the relevance, paragraph 21 of the said impugned judgment and award is reproduced hereunder. Next. This court further finds it relevant to take note of that during the course of the hearing, this court had put a pointed query upon the learned counsel appearing on behalf of the appellant insurance company as to whether any evidence have been adduced on behalf of the appellant insurance company proving that there was any fault on the part of the driver of the other vehicle. The learned counsel submitted that there was no evidence such led. There was no such evidence led. However, during cross-examination, it was admitted that there was a head-on collision. It is the opinion of the court that merely there being a head-on collision of two vehicles, the question of contributory negligence would not arise unless a proof evidence is adduced to the effect that there was the fault of the other vehicle which had resulted in the head-on collision. There was some fault of the other vehicle which had led to the which had led to the head-on collision. Considering the above, as the learned tribunal have decided and imposed the compensation upon the appellant insurance company, this court finds no ground for interference to the impugned judgment and award dated so-and-so, passed in so-and-so, by the learned tribunal, for which the instant appeal stands dismissed.
Item 5,
Yes, what is this?
That's an appeal file against the judgment passed by MSCT 2, in MSC case number 2402/2017. My lord, in MSC case number 2402 of 2017. My lord, at the very onset, I would like to make a very fair submission that in the coming Lok Adalat to be held on 13th, 14th June, this matter is had been given specific instruction to settle the matter. It was long back, but there was a dispute between claimant number 1 and 2. 1 was the wife of the deceased and 2 was the mother of the deceased. And 2, being the mother of the deceased, has disputed the fact that 1 has married off after the death of her husband to another person and converted her religion and had given an undertaking that she will not be asking for any compensation from this end. And that was one of the ground we have filed in the appeal. But it is a settled law that the wife of the deceased, till when he died, will be liable for compensation. Now we want to settle the matter, but
What is there to settle? You have no grounds. Deposit the amount, let them fight. Let them fight, both of them.
No, we don't have any dispute
now
whatsoever.
it is settled. Now it is because the claimant number 1 was not appearing for much of the time. That's why the matter got delayed. Now
It has been settled,
Yes, my lord.
so deposit,
yes.
matter over.
Well, it may be, as my lord submitted by my learned colleague, that if that has been rerouted to the Lok Adalat for speedy disposal, my lord, we are also.
Why do you need a speedy deposit in the local? Now only I dismiss his appeal, and he will deposit,
Yes,
matter
ma'am.
over.
My lord, I understand, my lord, there is 2 limited submissions that I want to make. My lord, in para number 24, while awarding the compensation, my lord, the loss of estate was not added. And secondly, my lords, condition was given that the fixed deposit will be, I have to keep the fixed deposit for 1 to 12 years in para number 29. My lord, I'm being a lady of, my lord, 70-plus-year-old lady. This condition would be a little harsh on me. I understand that I am not an appeal, my lord. This is just 2 submissions that I would like to bring to the attention of this court, my lords.
What?
My lords, in para number 24 is concerned. As per Pranay Sethi, my lords, there is no loss of estate was not added.
Then?
Well, it's in para number 29 in that is in page number 7. They say that it should be deposited as a fixed deposit in any nationalized bank for a period of 1 to 12 years. Now, looking at the fact that, my lord, I'm a 70-plus-year-old lady, this should be a condition which would be harsh on me, my lords, because to get the compensation, only that indulgence, my lords, if it is possible.
Now we have only 6 years left. 6 years have already gone. So only 6 years is left. Wait, you'll get a good amount. You can very well take out. Go there. You can very well file and to meet the urgent need, the claimant or the guardian of the minor can very well take out. You are mother.
Yes,
There are children also.
No, Sylvia, only two claimants.
Wife
Wife
and
and mother.
mother. There is no children.
No, Sylvia.
But you, without filing an application, how do I tell?
I understand, but my lords, without filing
But
an
as regards here, I can enhance this amount. Loss of consortium will have to be 80,000.
yes, my lords.
Then funeral expenses will be 15,000 plus there will be loss of estate of 15,000.
Yes.
So another 40 plus 15. It's say 55. 55,000 I can add out here. And thereby direct that instead of this 6,46,000 and 7,01,000 which is there, that will be now therefore the question is, I can only make one thing, that these will be now kept for 12 years, 6 years.
It is 1 to 12 years from the date of the judgment, my lord.
They have not deposited.
They have not deposited yet.
So therefore now it will be 6 years.
Yes, my lords. That may be reduced, my lords, or looking at my age, my lords. That's the only.
My lord, that plea can be taken before the trial court while taking out the check, my lord.
1 to 12 of my lords. I understand, my lords, it is 1 to 12 years, so therefore we'll submit before the trial court. And secondly, my lords, the interest part on the time of appeal, that will be taken care of during the trial court, my lords. That's the only submission. My lord, that's my limited submission, only with regards to estate. Loss of estate, which my lord has already,
No, not only loss of estate, loss of consortium.
consortium also, yes, my lords.
So there will be an additional increase by another 55,000.
Yes, my lords.
But that I can give it without there being also there, because it is the constitutional, it's the judgment of the Supreme Court, a constitution bench judgment. And following by another, the Magma judgment,
Yes, ma'am.
2021, Magma?
2022, my lord.
No, not 22. How much? What is it? Both of you are appearing, you don't know.
Look, I am, as far Pranay Sethi is concerned, my lord.
Pranay Sethi only says about 40,000,
Yes, my lord. That was being appealed in Magnum, my lord. That judgment.
not Magnum,
Magna,
Magna.
yes, my lord.
Magna judgment categorically said there will be a parental consortium as well as a spousal consortium. So therefore he is entitled to. What is the judgment of Magna?
My lord, that I will see, my lord.
So you are not aware.
I was aware, but my lord, I'll take that.
You deposited there,
My lord,
the amount.
my lord, only the points regarding the defense be cited, we have taken 3 plea. One was on the future prospect, 40% because he could not satisfy the trial court regarding the income. So the trial court has taken a minimum of 6,500, but that too also in 2024, we have, it is stated that future prospect is, because at that point of time when we filed, it was not there. So that point be added, and my lord, and we have taken the plea of contributory negligence. But to be fair in submission, we have not given any evidence as to.
And future prospects, what do you say?
Future prospect, my lord, the 40% was given, but the amount, the deceased, the claimant side couldn't prove the amount that he was being.
Future prospect
established.
will be on the basis of either he is working. There
He
are two
was a
aspects.
self-employed.
Huh?
He was a self-employed.
Self-employed.
But he was
Self-employed will also have future prospect.
Yes, my lord.
So how much? As per
No,
Pranay
as per-
Sethi,
as per Pranay Sethi, 40%, my lord.
this is okay.
It is okay, but at that point of time, it was not settled.
Because the judgment came in 2019, but Pranay Sethi is of 2017.
17, but there was a thing, my lord, that the amount has to be established. His income has to be established, whether self-employed or employed.
My lord, we had.
But
pleaded that-
later on, it was the apex court has settled it that it is not necessary to establish the income.
Chal. Heard Mr. C. Pupon, the learned counsel appearing on behalf of the appellant. And Mr.
M. Burman for claimant number 2, respondent number 2, my lord.
M. Borman for respondent number 2. You are as they for respondent number 1 and Mr. M. Borman for respondent number 2. This is an appeal filed under Section 173 of the Motor Vehicles Act 1988, for short, the Act of 1988. Challenging the judgment and award dated 19/8/2019, passed by the learned member Motor Accidents Claims Tribunal number Roman 2, Kamrup Metro, herein at Guwahati, hereinafter referred to as the Learned Tribunal, in MAC case number 2402/2017. whereby an amount of rupees 12,92,688 was awarded along with interest, along with bank interest fixed for fixed deposit from the date of filing of the evidence by the claimant, that is 19/3/2019. Full stop. The instant appeal has been preferred primarily on two grounds. First, that has been preferred on the question of unreasonableness in the quantum of the award of the compensation awarded. On the ground that the future prospect of 40% was taken without the claimant having proved the actual income. What is the second ground?
Second was on the ground of dependency.
Primarily on two grounds. First is on the question of quantum. First is on the question of quantum. That is, that the compensation so awarded was not in terms with section 168 of the Act of 1988, which stipulates that the compensation so awarded has to be just and fair, just and reasonable. Mr. C. Pukon, the learned counsel appearing on behalf of the appellant, submitted that in the instant case, the future prospects have been held at 40% without the claimants have proved the income of the deceased. The second ground of objection taken is on the question of contributory negligence, which was not taken into consideration by the learned tribunal, and thereby settling the entire liability on the appellant insurance company. Per contra, which one of you wants to put your arguments?
Member one, my lord.
Mr. So-and-so.
If I may, there's a third point regarding the dependency point, that we were filed the appeal that claimant number was not the dependent, as because he married off to another person.
Three korok. The third ground of objection so taken is that the claimant number
Claimant number one.
one, having married off after the death of the deceased, death of her husband, she would not be entitled to the compensation.
And has changed her religion. And has changed her religion.
How is this religion has to do anything out here? My goodness, don't make that submission. These are secular acts. So Mr. So-and-so, who appear, the learned counsel appearing on behalf of both the respondents, have equivocally submitted that both the claimants are entitled to the compensation. The learned counsel for the the learned counsels for the respondents further submitted that the future prospect which have been granted at 40% is in terms with the judgment of the Supreme Court in the case of, what is that?
National Insurance versus Pranay.
In the case of National Insurance Company versus Pranoy Sethi, reported in 2017 as 16 SCC, page 680. The learned counsel further submitted, drawing the attention of this court to the Constitution Bench judgment in the case of Pranoy Sethi Supra, that and as well as the judgment in the case of Magma Insurance Company versus so-and-so, reported in 2018 or something, huh?
2018 SSC 130.
2000?
2018 SSC 130.
130, and submitted that the loss of, in the instant case, the loss of consortium have been granted by the learned tribunal without taking into consideration that the loss of consortium includes the loss of spousal consortium as well as loss of filial consortium. Full stop. And as such, the amount which have been awarded in the instant case is less. The learned counsel for the petition respondents further submitted that in terms with the judgment in the case of Pranoy Sethi Supra, there's an additional amount which is required to be paid, that is on account of loss of estate, which is 15,000, which have not been paid. First, it has also been submitted by the learned counsel appearing on behalf of the petitioner, respondents, that in view of the judgment passed by this court in the case of, what is that name? That the learned counsel for the respondents further submitted that as the spousal consortium as well as the filial consortium, including the spousal consortium, the filial consortium, and the loss of estate, are based upon the law declared by the Supreme Court under section 141, under article 141, this court may enhance the compensation as the same would come within the ambit of just and reasonable compensation. First, let this court now therefore take note of the respective submissions made by the learned counsels for the parties. First, in the backdrop of the above, let this court now take note of the facts which led to the filing of the instant appeal. First, on 5/11/2017 at around 7 p.m., the husband of the claimant number 1 while riding a motorcycle from Narayanpur side towards Bhogpur by the left side of the road was knocked down by a truck bearing registration number AS02AC 7299. The husband of the claimant number one thereupon was taken to the hospital, but he succumbed to his injuries and expired. On the basis of the above, a claim proceedings was filed by both the claimant number, both the mother of the claimant of the deceased as well as the wife of the deceased, both the wife of the deceased as well as the mother of the deceased, as claimant number 1 and 2, which was registered as MAC case number 2402/2017. The appellant insurance company appeared and contested the case by filing written statement and denying the whole fact accident. Full stop. Various defenses were also taken, but surprisingly, there was no defense taken as regards contributory negligence. On the basis of the pleadings, the learned tribunal framed two issues, which are mentioned here in under page 11 of paragraph 7. In respect to the issue number 1, now who has adduced evidence? You have adduced evidence?
Yes, two DW.
There is two PWs, my lords.
Huh?
Two PWs.
And
One of the eyewitness, one of the claimant, my lord. That is in page number 8 of the judgment appendix.
from the materials on record, it appears that on behalf of the plaintiff, claimants, there were two witnesses. One was the claimant number 1 and the other was the eyewitness. On behalf of the defendant, there were two witnesses. On behalf of the appellant insurance company, there were two witnesses. The learned trial court or tribunal, while deciding the issue number 2, came to a categorical finding that the accident was caused due to rash and negligent driving by the driver of the vehicle bearing registration number AS02AC 7299. In respect to the issue number 2, the learned tribunal awarded a total compensation of rupees 12,92,668. And taking into account that the vehicle in question, the truck in question, had a valid insurance policy, settled the entire liability upon the appellant insurance company. It is under such circumstances the present appeal has been filed. In the backdrop of the above, let this court now take into consideration as regards the grounds of objection so taken. The first ground of objection which is being taken is on the question of future prospects. It is relevant to take note of that the deceased, what was the age of the deceased?
It was, Your Honor, so my lords, as per the post-mortem, it was 26 years, post-mortem report.
It is relevant to take note of that the deceased was 26 years when he met with the unfortunate accident.
As per post-mortem report, my lords. In para number 17 of the judgment.
As would appear, you see the question, as would appear from a perusal of
Para number 17.
paragraph number 17 of the impugned judgment and award. The deceased further was self-employed. And in terms of paragraph 59.4 of the judgment of the Supreme Court in Pronoy Seti, the addition of rupees 40, the addition of 40% there should be 59.4 of the judgment of the Supreme Court in the case of Pronoy Seti, comma, the future the future prospect which is required to be added is 40%. Considering the above, comma, the grounds of objection that the future prospect was not properly decided by the learned tribunals, in the opinion of this court, does not arise. The second ground of objection pertains to contributory negligence. First, it is well settled that for the purpose of claiming the defense of contributory negligence, there has to be pleadings as well as proof. Admittedly, there was no pleading to that effect, as well as any evidence being led to the effect that the accident occurred on account of the fault of the deceased. This court further finds it relevant to take note of the finding of the learned tribunal in issue number 1, wherein it was categorically opined that the accident was caused due to the rash and negligent driving by the owner of the vehicle bearing registration number AS02AC7299 truck. Nothing substantial could be shown to take any other opinion on this aspect. Considering the above, the second ground of objection do not arise. The third ground of objection is taken on the question of that the wife had remarried after the death of her husband. The claimant number 1 had remarried after the death of her husband. In the opinion of this court, the said ground so taken cannot be a ground to would have no basis on the adjudication of the just and fair compensation. Now let this court take note of the judgment of the Supreme Court in the case of Pronoy Sethi. Now let this court take note of the judgment of the learned tribunal. And more particularly at paragraph number 24, wherein on account of conventional head, only an amount of rupees 40,000 has been paid for loss of consortium and 15,000 on account of funeral expenses. But there is no amount being paid on account of loss of estate, which is the mandate of law as per the judgment in the case of Pronoy Sethi, more particularly at paragraph number 59.8. This court further finds it relevant to take note of the judgment in the case of Magma versus Insurance Company so-and-so Supra, wherein the Supreme Court categorically observed that the loss of consortium cannot only be limited to spousal consortium, but also would also be parental consortium and filial consortium. In the instant case, the claimant number one was the wife, and the claimant number two was the mother. However, the learned tribunal have only granted loss of consortium of rupees 40,000. Taking into account the judgment of the Supreme Court in the case of Magma Insurance Company, the appellant, the claimants were actually entitled to, each of the claimants were entitled to 40,000 on account of loss of consortium. First, this court further takes note of that the judgment in the case of the Supreme Court, in the case of Pronoy Sethi, Supra, as well as Magma so-and-so, Supra, are judgments passed by the Supreme Court in exercise of the powers under Section 141, which deals with, which are factors which are required to be taken for arriving at a just and reasonable compensation in terms of Section 168 of the Act of 1988. Therefore, in the opinion of this court, this amount of rupees 40,000, in the opinion of this court, that the claimants would be further entitled to an amount of rupees 40,000 for loss of consortium and 15,000 for loss of estate. Therefore, this court modifies the judgment and award dated 19/8/2019 by adding the amount of rupees 55,000, that is bracket of 40,000 plus 15,000 bracket close, to the already adjudicated amount, adjudged amount of rupees 12,92,668. And thereby, the entitlement of the claimants would be rupees so and so. This court, taking into account the judgment of the learned tribunal, taking into account the judgment of the learned tribunal, and there being no challenge on the question of quantum of interest.
But as in para number 28 is concerned, my lords, it was said that the insurance company had to submit the amount within 3 months. However, in the failure to do so, an additional one at the bank rate, in failure to do so, they have to add 1% from the date of claim petition, my lords.
We have before appeal, we can just stipulate the time.
What is the bank interest?
6%, 7%.
Taking into account the above, the additional amount so adjudged herein shall carry an interest in terms with paragraph number 28 of the impugned judgment and award. The learned counsel appearing on behalf of the respondent submitted that certain modifications are required in terms with to the direction so passed in paragraph number 29 of the judgment and award, taking into account that the claimant number 2 is an age-old lady and if the said amounts are kept in the FDR, it would serve no purpose for more particularly for the claimant number 2. It is the opinion of this court that if the claimants want certain changes to paragraph number 29, to the direction so passed by the learned tribunal in paragraph number 29, they can very well approach the learned tribunal and the learned tribunal, taking into account that already 6 years have passed by from the date of the impugned judgment and award, shall duly consider the said application. The appellant insurance company is directed to deposit the amount of rupees 13 lakhs along with the interest in terms with paragraph number 28 of the impugned judgment and award before the learned tribunal within 6 weeks from today.
I'm so
That's accordingly.
Obvious.
Yes. I agree.
My lord, this is an appeal for enhancement, my lord. The injured, my lord,
May I please lordship? My name is not shown because this case was, delay was, in the delay petition, I appeared. Subsequently, delay was found known. So paid for showing my name. But showing my name, I have received my copy of memo paper.
already I have served, my lord. I have served a copy, a memo of appeal.
There's a delay.
No, my
The
lord. no
delay is
delay.
already
No,
gone.
delay already.
I'm the respondent number 1.
Not at this stage, my lord, notice may go. Notice may go to the respondent number 2 and 3.
Injury.
Injury, my lord.
What happened?
My lord, appeal has been heard on 2 grounds, my lord. My lord, I suffered, my lord, 50% disability, but the learned tribunal held only 10%. And on the other hand, my lord, expenditure voucher, I submitted 6,40,000, but the learned tribunal held only 3,38,000. My lord, basically on 2 grounds, my lord, I have preferred this appeal.
Where is the observation in
My
paragraph
lord,
as
you lordship
regards?
kindly see impugned judgment observation, para 23, my lord. Para 23.
Yeah, these were exhibit 59 to 146.
59 to 146, my lord, expenditure voucher, my lord.
So the court finds it on the basis of that 3,38,000.
My lord.
Then
My lord, we, my lord, submitted, my lord, as per our calculation, my lord. My
how
lord,
can there be difference in calculation?
6,40,000 as per
So
our
you say that 6,40,000 is okay, but is it supported by documents?
documents, my lord.
Then why it was 3,38,000?
This is the, my lord, that's why, my lord, appeal, my lord. That's why, my lord, appeal has been preferred, my lord. My lord, on the other ground, my lord, the 50% disability suffered, only 10% held, my lord. My lord, that certificate was examined by my lord doctor. Para 2023, my lord. 23 and 26, para 26.
Why it was taken as 10%?
I do not know, my lord.
No, no, you know, paragraph 26.
Yeah, so having regard to the nature of injury that the injured sustained and taking note in the entire evidence as well as material placed before this tribunal, it would be just and proper to assess the functional disability of the injured claimant at 10%. In fact, my lord, the doctor, my lord, he assessed in the board, my lord, board, in a disability board, the doctor assessed the disability 50%, my lord. And that particular doctor has been examined, my lord. He came to the court and deposed.
Madam, admit, for the record, we have to examine. If it is found that there is a difference, we try to settle the matter in the meantime. Because I have nothing, no record, no anything.
You have not been given a copy.
No. Cross-examination. I will give you a file. So that I can.
Why do we need the owner and driver?
Otherwise, I think not
My
necessary.
lord, it is, my lord, actually, my lord, in the impugned judgment, my lord, perhaps they did not appear, my
This
lord.
is an enhancement case, my lord. Enhancement, otherwise there is a dispute, no, there is no
Because
dispute.
you will be delaying only.
Yes.
My lord,
You will be delaying only.
my lord, that may be deleted, my lord. If there is no
Deleted.
objection from my
This is an
lord.
appeal filed under section 173 of the Motor Vehicles Act 1988, challenging the judgment and award dated 11/4/2023, passed by the learned member of Motor Accidents Claims Tribunal, Gwalpara, in MAC case number 04/2020, awarding a compensation of rupees 6,03,252, along with interest at the rate of 7% per annum from the date of filing of the evidence on affidavit by the claimant. The, that is from 6/6/2022 till payment. The appeal has been filed challenging the quantum. There is no dispute as regards the liability of the appellant insurance of the respondent insurance company, that is the respondent number 1, to satisfy the award on the ground that the insurance company insurance policy was valid.
Well, only one, madam, not two. That's one number one.
Respondent number 1.
2 and 3 is the owner and driver.
Therefore, the question of proceeding with the instant appeal with the respondent number 2 and 3 does not arise. Accordingly, the respondent number 2 and 3 are struck off. Mr. R.C. Paul appears on behalf of the respondent number 1. An extra copy of the memo of appeal be served upon him. The grounds of objection taken in the present appeal are twofold. First, that the appeal that the learned tribunal did not come to a correct finding on the materials on record as regards the medical expenditure, inasmuch as the exhibited documents, as per the appellant, the entitlement towards medical expenditure was rupees 6,40,000. But the learned tribunal had only granted rupees 3,38,307. The second ground taken in the memo of appeal is that the disability certificate categorically stipulated 50% as the disability. However, the learned tribunal had only taken into consideration 10% functional disability. Taking into account the said grounds, the instant appeal is admitted to call for the records.
Well, showing my name on.
Yes.
The registry shall also indicate the name of Mr. Arsipo, the counsel appearing on behalf of the respondent.
Seven.
Appearing on behalf of the appellant shall file a fresh memo of parties before the registry of this court, and the registry shall, on the basis of the instant order, make necessary correction in the cause title as well as update in the CIS. Remove these two, only he is there. Yes, what is this, Mr. Mondal?
Your Lordship, I sustain three kinds of fracture. And for 86 days, I was hospitalized. The learned tribunal awarded me only 10,000 as pain and suffering, pain, shock and suffering. That is one ground. Another ground, Your Lordship, if Your Lordship come to paragraph 20 of the judgment. Paragraph 20. Here I have exhibited 17,15,354. But the code given me 7,05,521, showing some reason. But
Who is to pay?
United India. That is respondent number 3.
You are paying for whom?
Respondent number three.
And had it been found out of there that the insurance is valid?
Yes, sir, they have paid, they have satisfied the award. They have satisfied. I was traveling in the, deceased was traveling in the Bolero.
So they have satisfied it.
Another, they are insurer of the truck.
So
Truck
then,
hit me.
then we don't require the others?
Not necessary. I have taken steps in the delay application. They have not appeared.
No, we don't take, we remove 1, 2, 4, 5 and 6.
Yes, Your Lordship.
We have only 3. This is an appeal filed under Section 173 of the Motor Vehicles Act 1988, challenging the judgment and award dated 25/7/2022, passed in MAC case number 523/2013 by the learned member, Motor Accidents Claims Tribunal number 3, Kamrup Metro at Guwahati, whereby an amount of rupees 7,65,521 was awarded as the total compensation, along with interest at the rate of 7.5% per annum from the date of closing of evidence of the claimant, that is from 30/8/2018 till the date of payment. It has been submitted by Mr. D. Mondal, appearing on behalf of the appellant, that the respondent number 3, which was the insurance company of the vehicle in question,
Insurer of the offending truck.
of the vehicle in question, which caused the accident, had already satisfied the award by making due payment. Full stop. He, however, submits that the instant appeal has been filed, enhancement of the compensation. Taking into account that there is no denial that the respondent number 3 insurance company is required to satisfy the award, the necessity for pursuing the instant appeal against the respondent number 1, 2, 4, 5, and 6 does not arise. Accordingly, the respondent numbers 1, 2, 4, 5, and 6 are struck off. And the respondent number 3 is arrayed in the instant appeal as the sole respondent. Ms. So-and-so appears on behalf of the sole respondent and accepts notice. Extra copy of the instant appeal be served upon her. First, the grounds of objection taken in the present appeal are twofold. First, that the evidence so adduced in respect to the bills and vouchers were of the value of rupees 17,15,354. However, the learned tribunal had arbitrarily reduced the amount to rupees 7,05,521 without assigning any reasons. The second ground of objection is taken is that the learned tribunal had only granted awarded an amount of rupees 10,000 towards pain and suffering without taking into consideration that the appellant have been in hospital.
May I please, your lordship? In spite of that, all the general damages has been awarded on the lower side, 5,000, 10,000 like this. I have taken one ground also. All the general loss of, since it is a disability, I have suffered disability. Since I was working, so I will not get any loss of income, but it is a disability case. So in case of disability, some heads are specified. And these are very on very lower side, 5,000, 5,000, 10,000, 5,000. The general damages, non-pecuniary.
Attendant charge 5,000.
5,000. I was treated as Delhi. My cost of attendant will be only.
The second ground of objection so taken that in all other conventional heads, the amount which have been granted is on a lower side without taking into account the evidence on record. Taking into account the said grounds of objection, the appeal is admitted. Call for the reports.
Your lordship, I have to file one.
On file and the appellant, the counsel for the appellant is directed to file a fresh memo of party before the registry of this court, and on the basis thereof, the registry shall make necessary correction in the post title and update in the CIS.
Highly obliged.
Item 8.
Yes, Mr. Vishwas,
Yes, my lord, we have come for enhancement of the award, my lord.
what is the ground?
Ground, my lord, the multiplier was taken into consideration is 13. My mother was 45 years old. My lord, it is judgment of the Maya, this is Maya Singh 2025 Supreme Court. It said 45 up to 41 to 45 multiplier should be 14. Not 13.
Only that?
No, there is a, interest was almost 6%, my lord. And my lord, future prospect was not properly considered.
Why?
And regarding my lord, consortium, it was, as your lordship has pointed out in new judgment, my lord. Here it is only 48,000, my lord. 48,400. Base, it's 65 kind
How
of.
many were there?
Beg your pardon?
How many claimants were there?
Three.
Huh?
Three, son and daughter.
Who died?
Mother died. She was running a poultry farm.
Mother died.
Yes. And my lord,
And
notional
appellant
income
number,
also accepted.
claimant number 1 is who?
Son, other two are daughter. Two
Mr.
is also
Nazari
son,
and
one is
Tharali are daughter.
Third is the daughter.
2 sons and 1 daughter.
Yes.
Is an appeal filed under section 173 of the Motor Vehicles Act 1988, challenging the judgment and award dated 19/4/2024 passed in MAC case death case number 10/2022 by the learned member Motor Accidents Claim Tribunal Sinam at Kazalgaon, whereby an amount of rupees
5,72,200.
5,72,200 have been awarded, along with interest at the rate of 6% from the date of filing of the application till payment or realization of the same. Pusto. The grounds of objection so taken in the instant appeal are: number one, the multiplier so adopted of 13
Yes.
was not in accordance with law, taking into account the recent judgment of the Supreme Court in the case of
Maya Singh versus Oriental Insurance Company.
Maya Singh versus Oriental Insurance Company, reported in
Reported in Malad.
Give it to me. What was the age?
Date is, I don't find Malad. Very recent judgment, Malad. That is true.
Huh? What was the age of the victim?
45.
Why do we require this?
Because of multiplier, Malad, regarding.
Here it is also given. At paragraph 30 it is given. But why it was taken?
Court has given 13. It should be
13
14.
is being given at 46. What was the age? In a case,
45,
I
yes,
find
45.
that the deceased
From the
was the ground of objections taken are: number one, the appropriate multiplier was not applied. Mr. S.C. Biswas, the learned counsel appearing on behalf of the appellant, drew the attention of this court to paragraph number 25 of the impugned judgment, wherein the learned tribunal had arrived at the finding that the deceased was 45 years of age. The learned tribunal, the learned counsel further stated, drawing the attention to paragraph number 30 of the impugned judgment, wherein it has been mentioned that the multiplier 14 would be applicable for those persons from 41 to 45 years of age. He therefore submitted that the multiplier of 13 could not have been applied in the instant case. The learned tribunal, the learned counsel further urged that on account of loss of consortium, there is no, the amount so awarded was less, taking into account that only an amount of rupees 48,400 have been awarded without taking into consideration that there were 3 claimants who were the sons and daughters of the deceased. Further to that, the petitioner, the appellant further alleges that the interest at the rate of 6% was on the lower side. Taking into account the said grounds of objection, the instant appeal is admitted, call for the record, steps be taken by way of registered as well as
liberal.
9.
Lordship, appellant claim petition was dismissed for default.
Dismissed for?
Dismissed for default. Page 61, Lordship, impugned order.
Yes.
Lordship, on the earlier date, the youngest advocate was present, Lordship. Order sheet I have annexed, Lordship, page 47, annexer 7, page 47, Lordship. Lordship, height order dated 21/2017, notice was issued and steps was taken. The respondent number 3 insurance company appeared and later on filed, but regarding service, respondent number 1 and 3, owner and driver was not served. And subsequently, 3 days after, on 24/5/2017, written statement was submitted by the insurance company. And second steps was taken on 30/11/2017, page 49, Lordship. And height order 19/5/2018, the license was given for taking steps, but that was not taken by the.
Did the other side appear on the last occasion?
So there was a delay petition and in the delay petition, all the respondent appealed.
Huh?
There was a delay petition in this appeal and.
Forget
others-
about that. Before the
No,
tribunal.
only respondent number 3 insurance company appeared and owner and driver notice
No,
was not
did the respond number 3 appear on 21/6/2018?
Lordship. That appeared and submitted written statement also.
The council, what am I asking it? Kindly come to paragraph, page 61. Who appeared? So nobody appeared.
Nobody appeared for the claimant side.
Hello, we allow this appeal.
I have, my lord. Respondent number 1 and 2, my lord.
Fantastic. Very good. We allow this appeal. But this appeal has been dismissed. Go and appear, all of you.
Lordship.
Matter over. Because it is only on the question of service.
Lordship.
Now you are appearing for 1 and 2, the owner and driver, and you are the insurance company. So nothing means so that everybody appeared. Hello. Did an appeal file heard, Mr.
A Hussein.
So and so appearing on behalf of the appellant and Miss So and so appearing on behalf of the respondent number 3 and Mr. So and so who appears for the respondent number 1 and 2. That was what like 1, 2, 3. This is an appeal filed under section 173 of the Motor Vehicles Act 1988, challenging the orders passed by the learned member Motor Accidents Claims Tribunal, Bozali, whereby the claim proceedings was dismissed on 21/6/2018 on the ground that the claimant was not represented. Subsequently, an application was filed under Order 9, Rule 9 of the Code of Civil Procedure 1908, which was also dismissed by an order dated 7/8/2018. And it is under such circumstances the present appeal has been filed. This court finds it relevant to take note of that that on 21/6/2018, the appellant did not appear for which the case for which the claim proceedings were dismissed for non-prosecution, for non-appearance. It is relevant to take note of that on 21/6/2018, none has appeared on behalf of the respondents in on behalf of the opposite parties in the claim proceedings. Under such circumstances, the provisions of Order 9, Rule 3 would have been applicable. Be that as it may, on account of mistaken advice, an application was filed under Order 9, Rule 9 for restoring the appeal which was dismissed for non-prosecution, claim proceedings which was dismissed for non-appearance. The said application was also rejected by the order dated 7/8/2018, and it is under such circumstances the present proceedings have been filed. This court further takes note of the provision of Order 9, Rule 4 of the Code, which permits that a fresh application, therefore, this court further takes note of the fact that when the accident happened, the accident for which the claim proceedings was filed was prior to 1/4/2022. 1/4/2000. And as such, by virtue of Order 9, Rule 4, the claimant could have filed a fresh claim proceedings also, as there was no bar in view of the proceedings of Order 9, Rule 4. Filing a fresh proceedings, full stop. It is further seen now that all the respondents are duly represented before the court. And taking into account that the proceedings for the claim proceedings under the Motor Vehicles Act 1988 are in the form of a benevolent legislation, this court, in exercise of its appellate jurisdiction, restores the said claim proceedings to the file of the learned court of the court of the learned member, Motor Accidents Claims Tribunal, Bozali. Full stop. The respondent, the appellant, as well as the respondents who are duly represented, are directed to appear before the learned member, before the court of the learned member, Motor Accidents Claims Tribunal, Bozali, on 16th of June 2025. The learned member, Motor Accidents Claims Tribunal, Bozali, is directed to proceed with the claim proceedings in accordance with law. This court, however, finds it very pertinent to observe that taking into account that the instant claim proceedings have been revived after a period of 8 years from the date the said original claim proceedings was filed, the appellant herein, who is the claimant, shall not be entitled to the interest on the claim proceedings for a period from the date of filing of the claim proceedings till to date, if in the circumstance the learned tribunal awards any compensation to the petition.
Then
This is for enhancement mallet, death case mallet. Mainly on the ground mallet, the deceased by the driver mallet, and mallet, his income per month was claimed as rupees 15,000. But tribunal since found that there is no evidence to that effect, mallet, tribunal awarded rupees 6,000 mallet. And mallet, second ground is that mallet, in this case, interest awarded at the rate of 6%. And my lord, for the period of about 14 months, no interest is awarded due to the COVID, my lord. My lord, the finding with regard to income, lordship will find at page 17, my lord, issue number 3, my lord.
Issue number?
See, page 17.
So it is only on the question of quantum.
Quantum.
So you need more money.
Yes, sir.
Did you prove the document
My lord,
that you were earning 15,000?
my lord, there is no income certificate, but the driving license of the deceased was exhibited, which shows that he was having a professional license, my lord. And my lord, the vehicle involved in the accident, he was driving at that time, that is in his name only, my lord. The deceased, my lord.
So income tax?
My lord, 15,000, my lord, he is not taxable, that is not under the taxable income, my lord.
Huh? So anything, any document,
My lord,
merely having a driving license would do.
my lord, driving license.
Tomorrow, you may say this person have passed out MA Arts. So,
My lord, since he was driving his own vehicle, my lord, that was a goods carrier, my lord.
so therefore, if you have his own vehicle, you could have purchased it only from some income. You could have purchased, you must be either paying loan.
Lord, all these documents are not
So
exhibited.
what is wrong with therefore fixing at 6,000?
My lord, my submission is that, my lord, since if I am able to prove, satisfy your lordship that he was a driver, then at least as per the minimum wages act, my lord, that whatever, because the driver is a skilled labor, my lord.
Huh.
The amount under the minimum wages act.
Argued it. Did you argue it? Or it became clever when it landed in the hands of Mr. A.K. Gupta?
But my lord, the documents are exhibited. It is not that, my lord,
You
nothing.
didn't exhibit anything. That is what the learned tribunal holds.
The driving license exhibited and, my lord, all the.
Driving license exhibited, that doesn't make any sense.
And, my lord, all the documents of the vehicle are already seized, my lord. That the seizure list was exhibited, my lord.
So if you had a car, obviously you would have shown something. A driver, you are not a driver, you are the owner of the vehicle.
The owner as well as driver, that is a goods carrier vehicle, my lord.
Therefore, and that met with an accident.
Yes, my lord.
With?
With one another vehicle.
And what is the finding?
My lord,
Contributory negligence?
no, my lord, issue number 2, page 17, there is nothing with regard to contributory negligence.
And who? An appellant and respondent insurance company?
My lord,
Issue number 2, how is it decided?
my lord, page 17.
As we scrutinize the evidence, including the area, we find no evidence which may suggest that there was a contributory negligence of both the vehicles so and so. And the next ground is?
My lord, interest, my lord. that,
Interest is okay.
My lord, 6% and, my lord, for 14 months, my lord, it says, my lord.
14 months only.
My lord,
Why does it take such a long time for doing this matter?
my lord, there is no fault on the part of the.
2019 you have filed.
Yes, my lord.
Why does it take such a long time? When did the accident happen?
So accident took place on 10/12/2018, my lord.
So then you filed in 19.
2019.
Then, so they have given you insurance. Now, there is an appeal filed under section 173 of the Motor Vehicles Act challenging the judgment and award dated 7/2/2025 passed in MAC case number 38/2019 by the learned member Motor Accidents Claims Tribunal, Tinsukia, whereby an amount of rupees
7,45,800.
rupees 7 lakhs 45,800 have been awarded along with interest at the rate of 6%. The grounds of objection taken in the instant appeal are twofold. First, the deceased was a professional driver who was driving his own vehicle. And compensation so awarded and the monthly income of the deceased was taken merely at rupees 3,000 without taking into account that the deceased was a skilled personnel for which the appropriate monthly wages for skilled personnel issued under the Minimum Wages Act 1948 ought to have been taken. The second ground of objection is that during the period of the COVID, no interest have been awarded. Taking into account the above, the instant appeal is admitted, call for the record steps be taken by way of registered as well as usual.
But in this case, 1 and 4 may not be required, my lord. So I say that may be a stuck of me.
Ah.
Respondent number 1 and 4, my lord. 1 is the driver, my lord, and respondent number 4 is the insurance of the vehicle given by the deceased, my lord.
One is who?
Driver, my lord.
Four?
4 is the insurer of the vehicle driven by the deceased, my lord.
Who is two?
2 is the owner of the vehicle, my lord. The offending vehicle, my lord.
So the direction is being given to whom?
Direction is given to insurance company to pay and then recover, my lord, because there is a.
Let it be made.
All right.
11.
If the appellant is the insurance company, your lordship. And this award has been passed by the MSCT test school, lordship. The award is 23 lakhs 85,600, your lordship.
Ground of objection?
Yes, lordship. First of the lordship, my first ground of objection is that, lordship. The deduction, lordship, should have been 1/3 instead of 1/4, lordship. Here only 3 respondents and claimant has preferred this claim case, lordship. And other legal errors were not made a party, lordship. No authority was taken, lordship. Their evidence was not taken. And this learned tribunal has erroneously taken the respondent as 5, your lordship. Although there were only 4 respondents, lordship. That's why it should be 1/3 reduction, lordship. Second one, your lordship. Again, 40,000 each was given to 4 legal heirs of this claimant, lordship. 40,000 each, 1,60,000 awarded. Again, lordship, the funeral expense and loss of estate are on a higher side, your lordship. That is page number 20 and 21 of this judgment, lordship, award.
Why?
It is given 25,000 and 30,000. That is a higher side, lordship. As per pronounceability, lordship, it should be 15,000 each, lordship. That is another my ground. Again, another ground is that exhibit 10, which was a salary certificate, that was not proved according to the law. Because your lordship, according to the law, lordship, because
Well, what was not proved?
it was not proved, lordship.
Which one?
The salary certificate marked exhibit 10 by CW3. My objection is that, lordship, he was a not authorized person, lordship. He was only a professional CA. It is evident in the award, lordship, page number 20. In page number 20, he has stated that, lordship, it has been observed by the Honorable Tribunal that he was a professional accountant and the proprietor of that firm, your lordship. He was not called for as a witness, and the salary certificate that is marked exhibit 10, his signature was not there. The proprietor's signature was not there. It is already been admitted, and the income has been taken as 14,900.
What was he doing? The deceased?
He claimed that he was working under some unique drug distributor.
As?
It is not clear. He only said that he worked under unique drug distributor. I don't have that certificate, lordship. LCR will reveal, lordship. This is one ground, and the last ground is that the interest has been awarded on future prospect. That is another ground, lordship. But the main ground is that, lordship, respondent has been taken as 5. If you go to the
page number 21, the Learned Tribunal has stated that total family members, including deceased, were 5. But your lordship, you can see in the lower portion, lordship, that is the loss of love affection has been given to 4. Actually, they were 4, lordship, but they were not made a party, nor their evidence were taken. So hypothetically, no evidence was taken in the trial case, lordship, that those are my dependents. They were not called as a witness, nor they were made as a party. Only the claimant number 1, that is the wife of the deceased. He preferred this claim petition. She preferred this claim petition, lordship. So it should be 1/3. It should have been 1/3, lordship, because they were not there. So this is only for quantum, lordship. We are agreed on this only.
So how much as per you should pay?
Lordship, it should be calculated. It should be for funeral expenses and its loss of estate 50,000, 15,000, lordship. Addition may be given to 10%, lordship, as per promissory, lordship. And it should be deducted to
Mr.
1/3,
Counsel, how
lordship.
much?
Lordship, I have to calculate them.
Calculate and come back.
Lordship,
Then-
again, the salary certificate, lordship, LCR will leave in, lordship. The
You
salary
see,
certificate,
it's here.
lordship,
First you have to deposit.
lordship.
You,
Lordship, we are ready to deposit
how much?
50%.
And what is this? Stay application.
No.
So therefore the question is,
I will
Therefore, the
I will
question
file a
is
separate,
how
lordship,
much
because
it
it is
is.
past date, lordship.
no, not like this. I will exercise the power under order 41
Yes,
rule
sir.
1(3) and allow you to proceed only after disposal.
So item number 35, 36, 37 listed for hearing, my lord. But I came to know there is a medical emergency at my home, my lord. I am appealing that for the respondents. So for the today, it may be adjourned, my lord.
Lordship, I'm appearing for the appellants, considering the matter being an old one, if a short date may be fixed, my lord.
We will hear you,
My lord,
then if necessary, we will hear her
my lord,
on another date.
my lord.
Yes, sir. I will not be here, my lord.
Your presence is excused.
Yes, my lord.
We will, if necessary, if I dismiss his case, then
Yeah.
what is your problem?
My lord, some medical emergency, my lord, I am going.
Understood. If I dismiss his case, you should be happy.
No, my lord.
What?
No, it should be on merit, my lord. It should be on merit, my lord.
I'll dismiss his case on merit, then what is your problem?
Problem.
So then, and if I think of allowing it, I'll hear you on another date.
Okay, sir.
My lord.
Item 12.
May it please your lordship, appealed by the claimant, your lordship, and mother of the deceased, your lordship, for enhancement of the award. And your lordship will find at page number 20 and 21. 21, your lordship, the future prospect was not considered. In fact, it was future prospect was given only 10,000. And what happened here, the claimant filed a certificate, income certificate, your lordship. But the writer of the income certificate was not, did not come to the court and exhibit it. It was exhibited by the mother. So that was not considered. But in the evidence, your lordship, there was simply a denial that there was a suggestion that he is not working in such and such construction. And at the end of the learned tribunal came to the conclusion that notional income, which was 9,000, they calculated in rupees 9,000. And upon that, no future prospect was given. But as per Honorable Pranay case, your 30% ought to have been given. These are the main grounds, your Honor.
What was the age of the victim?
28, your Honor.
28.
28,
So 40% should have been given.
40%.
There is an appeal filed under section 73 of the Motor Vehicles Act challenging the judgment and award dated 26/11/2024, passed in MAC case number 110/2022 (D), whereby an amount of rupees
10 lakh 30.
10,13,000 was awarded along with interest at the rate of 6%, 7.5% per annum from the date of filing of the case till realization. Mr. B. Pusilas, the learned counsel appearing on behalf of the appellant, drew the attention of this court that in terms with that the learned trial court, the tribunal, had awarded an amount of rupees 20,000 on account of future prospects without taking into consideration the mandate of the law in the case of National Insurance Company Limited versus Pranay Sethi and others reported in 2017-16 SCC 680, which stipulates that the future prospect has to be calculated at the time of arriving at, which stipulates 40% as the future prospects to be awarded in case of a victim who is below the age of 40. In the instant case, the victim was only 28 years old. 28?
28 years.
Who's taking into account the
Yeah.
said ground of objection, the instant appeal is admitted, call for the record steps be taken by way of registered as you.
Your Lordship, another ground that is the exhibit 15, Your Lordship, exhibit 12, that was not good, the salary certificate. Though there was no rebuttal of the same.
In addition to that, appeal admit in addition to that, it has also been submitted that exhibit
Exhibit 12, page 20, Your Lordship will
12,
find first line,
which
Your
is
Lordship.
the salary certificate,
Salary certificate.
have not been taken into consideration by the learned tribunal. Taking into account the said grounds of objection, the appeal is admitted, call for the record steps be taken. Now, who is to pay the amount?
The respondent number 3, the insurance company.
Then why you are making the others a party?
Your Lordship, though they didn't appear in the learned tribunal.
Is it any order of pay and recovery?
No, no,
Has the respondent number 3 have already paid the money?
no, they have not deposited.
13.
Apply.
Yes, Mr. Usami.
It's against an award of rupees 25,11,600. That's the main ground. Lord. And the other ground was, I'm not pressed that it was on contributing negligence. There's no positive evidence.
What is the ground?
The main ground is Lordship, the income.
Income has not been?
Has not been proved. It isn't taken as Lordship 13,000. And the award has come to 25,11,600.
What is the basis of arriving at 13,000?
He had a driving license.
Hmm?
He had a driving license. One of the vehicles, drivers, there's a collision between two vehicles.
On the basis of this, minimum wages, 12,83,000. And what driving license he was having?
All kinds of Lordship.
Professional?
I think so. I remember Lordship. Professional license for Lordship.
Professional.
I'll just check. Lordship. Yes, Lordship. Professional license, authorizing him to drive transport as well as non-transport vehicles.
And what was his age?
35 years, 9 months.
So what is wrong?
Was not proof that he was a driver actually. He might have had a license. Some evidence should have been.
But was he driving the vehicle?
He was driving one of the vehicles.
Okay. Second is, in view of the Supreme Court judgment in 2021, it says that if nothing is there, then kindly look into the Minimum Wages Act. The fact that he was a professional driver, so therefore he will be, and here it has been given at 12 lakhs.
So he had a license, he must have, he is eligible to become a professional driver. But there is no evidence that he was employed by someone, or maybe he was driving agent. That kind of evidence was not there. His own statement that had to be taken.
The other ground lordship that I had taken, I will not press it because I did not need any positive evidence. But normally lordship, the sketch map is 1/8 that is taken up by the non-member. In this case, the sketch map was not there. I've seen the list of documents at the end of the judgment. Others are there. So that sets me thinking lordship whether this could have been,
Contributory.
it ought to have been a part of the search sheet. It's not there.
Only problem which arises, Mr. Goswami, is this. For me to admit this appeal like this, there's no problem with them directing 50%. At the end of the day, the insurance is affected more.
I understand. I understand. The right
Taking into account the Supreme Court judgment wherein it is to be taken, and he had their license which is there and they have put it at 12,000.
I'll not press my case further. Lordship.
12,838.60 per month. Presumption can be raised that the deceased, being a professional driver, is capable of earning 13,000 per month, and 13,000, if accepted as a notional income, appears to be reasonable. Contemplate relying upon the demand of professional and income being 15,000 per month. It is also held that in absence of a salary, the minimum AR can be yardstick, but at the same time cannot be an absolute one to fix the income of year. As the deceased was below 40 years at the time of his death, there should be an addition of 40% AR. Everything seems to be okay. Claim?
Your Lordship, I do not have Wakalat number right now, but appearing on behalf of respondent number 1, 2, and 3, Your Lordship.
Claimant?
Claimants.
Dismiss.
Yes.
Heard Mr. R. Goswami, the learned counsel, appearing on behalf of the appellant insurance company. Mr.
A.N. Iqbal.
So and so appears on behalf of the respondents numbers 1,
One,
2, and 3, who are the claimants. It is an appeal filed under Section 173 of the Motor Vehicles Act 1988, challenging the judgment and award dated 17/3/2025, passed in MAC case number 1886/2020. First of the instant appeal is being taken up at the stage of Order 41, Rule 11 of the Code. First of the ground of objection so taken in the instant appeal as submitted by Mr. R. Goswami is that the salary, that the income of the appellant, of the claimant, of the deceased was not proved. And as such, the learned tribunal had erred in arriving at a figure of 13,000 to be the income, monthly income of the deceased was erroneous and liable to be interfered with. Full stop. Taking into account the said ground of objection which is in relation to the quantum, let this court have taken up the instant appeal for disposal on the basis of the materials which are already available on record. Full stop. The brief facts which led to the filing of the instant appeal are that on 21/11/2020 at around 7:30 p.m., the deceased namely Abdul Wahid was proceeding from the Lamding side towards Lonka side by driving his own Spatio bearing registration number AS02AB4195. On the way at Chakma Tila on NH54 under Lamding police station, the Scorpio bearing registration number AS02AB4195 coming from the opposite direction, being driven by its driver in a very rash and negligent manner, had knocked down the Spatio vehicle and from the wrong side, resulting in grievous injuries to the to Abdul uh, to Abdul Wahid, who to the husband of the respondent claimant number one, resulting in grievous injuries and subsequently succumbing to such injuries. On the basis thereof, an Lamding PS case number 227/2020 was registered under section 279-304A of the Indian Penal Code against the driver of the vehicle bearing registration number AS02B 02AB 4195. Full stop. On behalf of the thereupon, the claim proceedings was instituted, which have been registered and numbered as MAC case number 1886/2020. Full stop. Notices were duly issued to all the respondent opposite parties in the said proceedings. Full stop. It is seen from the impugned judgment that the the appellant herein, who was the opposite party number 3, had filed its written statement and pleaded that the claim proceedings was not maintainable either on facts or in law. Further to that, various preliminary objections were taken as regards the maintainability of the claim proceedings. In the said written statement, the appellant had duly acknowledged that the issuance of the policy in respect to the vehicle bearing number AS02AB 4195, which is the offending vehicle, but denied the maintainability of the claim proceedings under section 166 of the Motor Vehicles Act 1988. First, on the basis of the pleadings, the learned tribunal had framed two issues, which are as hereinunder, page 12 of the paragraph 6. On behalf of the appellants, on behalf of the claimants, two witnesses were adduced and various documents were exhibited. On behalf of the opposite party, the appellant, there was neither any witness examined nor any document exhibited. It is relevant to take note of that Exhibit 7.1 is the driving license of the deceased. The learned tribunal, while deciding the issue number 1, came to a categorical finding that the accident occurred on account of the negligence on the part of the driver of the alleged offending vehicle bearing registration number AS02AB 4195. Full stop. In respect to the issue number 2, the learned tribunal arrived at a finding that the just and reasonable compensation would be rupees 25,11,600. In doing so, the monthly income of the deceased was adjudged on the basis of the driving license, the professional driving license, which is Exhibit 7.1, and applying the notification by the Labor Welfare Department, Government of Assam, the minimum wages for a skilled labor being fixed at rupees 12,838.60 per month, with effect from 1/1/2020, the learned tribunal arrived at the figure that the monthly income is 13,000, can be presumed to be 13,000. On the basis thereof, the learned tribunal had arrived at the amount, the compensation of rupees 25,11,600 Full stop. This court have duly taken note of the j- the findings of the learned tribunal in that regard, and more particularly more particularly as regards paragraph number 22, 23, and 24, which in the opinion of the court, of this court, appears to be just and proper. The said paragraphs, being to a paragraph number 22, 23, and 24 of the impugned judgment and award being relevant, is reproduced hereunder. This court further, taking into account the above observations of the learned tribunal, this court is of the opinion that the said opinion that the fixing of the monthly income at rupees 13,000 cannot be said to be excessive, more so in view of the judgment referred to by the learned tribunal at paragraph number 24 of its judgment as quoted herein above. This court further takes note of that in respect to the that while fixing the compensation, the learned tribunal have duly taken into account they have duly taken into account the various other parameters as settled by the Supreme Court from time to time. So considering the above, this court finds no ground for interfering with the instant appeal to the impugned, no ground for interfering with the impugned judgment and award dated 17/3/2025, for which the instant appeal stands dismissed. The tribunal, the appellant insurance company is directed to deposit the amount of rupees 25,000, deposit the amount as ordered by the learned tribunal at paragraph number 32 before the learned tribunal within 6 weeks from today. The learned tribunal, upon deposit of the said amount, shall apply the same in terms with paragraph number 33 to 35, 33 to 36 of the impugned judgment and award. Further to that, the learned tribunal, upon an order being produced about deposit of the aforesaid amount of rupees 25 lakhs 11,600 along with the applicable interest before the learned tribunal, and the same being produced before the registry of this court, the statutory deposit so made by the appellant insurance company before the registry of this court at the time of filing of the appeal be allowed, be returned, refunded. Appeal stands disposed, I stands closed.
14.
Oh, in your case earlier, you earned the 25,000 back.
I was just about to.
It was আগৰ এই কেছ এটা তেখেতে কৰিছিল।
Item number 4.
তাত লিখি দিব সেইটোৱে last line to the payment to deposit within 6 weeks upon producing the order of that court of deposit before the learned registry and registry. Yes, what is your case?
The bill is dictated by the insurance company. Here the deceased was the government employee. He was a police constable. So Lordship is aware about the government notification dated 14/9/17 that dependents will be getting the entire salary of the deceased. So one of the ground is that, Lordship. And the learned tribunal, apart from giving a 6% interest, Lordship, a default added interest of 9% per annum has also been added.
Now, why it was given on future prospects at 50%?
Future prospect 50%, Lordship, he was 30 years of age, but no boundary was because as per settled law, Lordship, after 50 to 60 years, there will be no future prospect. The deceased was 30 years. but there was no boundary drawn by the tribunal. And beside that.
So here the tribunal gave only 50 future prospects,
Future plus 50%.
only on future prospects, nothing, not on other aspects.
However, the disease was of 30 years of age.
Huh?
In the age group of 30.
So here the tribunal only granted on future prospects. Plus loss of consortium, it's okay. Loss of estate, okay. Funeral expenses, okay. Then
The default interest of 9% in addition to the 6% interest also given. Lordship may come to para number 29, Lordship. The Indian judgment. In the last part, Lordship.
so you are only on the 9%.
9% and he was a government employee, Lordship. So the fact.
Understood. Government employee, what about the future prospects?
Future prospect, Lordship, as per the law, Lordship, after 50 to 60 years, he will not be able to get any future prospect. That is one of our contention.
So therefore, he has been put at 50% on that income. What is wrong? He died at the age of 30.
Yes.
Then
And Lordship, regarding the interest during the COVID period also. It is
while determining the income and addition of 50% of the actual to the income of the deceased towards future prospects. Where the deceased has a permanent job and was below the age of 40 would be made. Then
Lordship, may kindly see our ground number A, Lordship, in our bill. Ground number A. Page number 4, Lordship.
yes.
And as per settled law, there will be no addition for future loss of income after the age group of 50 to 60 years. The learned member, ignoring the settled provision, directed the appellant company to pay compensation of future prospect 50%, which is contrary to the statutory provisions as decided by the Honorable Apex. So Lordship may admit the appeal and we are ready to deposit 50%. Whereas I also are ready to deposit 50%.
No, the question is either you have to pay or you don't have to pay. There is no upfront. Because once you pay this 50%, then there is a big problem. How do you get it back?
Withdrawal may not be allowed.
That I allow.
Same species.
Then it makes no sense making the register general rich with the interest. Isn't it?
But Lordship may also go to the default interest which the learned tribunal has considered. Default interest of 9%. In addition.
That will take care of. That will make it 6%. Then happy to deposit. Take your instruction.
So I'll take instructions. One chance may be given.
The counsel appearing on behalf of the appellant submits that he would obtain instructions in the matter. Taking into account the list of matter again on 30 May 2025.
15.
So for inadequate compensation, on the ground that income proof was not considered. Although it exhibits 6 and 7, exhibits he was a retired school teacher, and his bank statement was exhibited, and he was also owner of a tea estate. Certificate, owner of a tea estate, So income certificate was also.
Owner of?
T-state, my lord.
What?
T-state,
T-state.
after retirement, my lord. So he is 70 years old. And my lord, notional income was taken as my lord, 9,000 per month. So income certificate and my lord, his pension was not considered.
Income certificate is what?
Income certificate issued by my lord, income from the my lord, T-state. That was not considered.
You must have filed the income tax returns.
My lord, that is not in the record, my lord.
You must have shown the ownership of the land of the T-state.
T-state, my lord, they have only my lord put a suggestion that I do not own a.
No, I am asking you, did you own the T-state? Then
No, my lord, T-state, I own, my lord, but
where is
no
that?
document, no document.
Then,
No document.
then you don't prove that. How do I
But
help
my
you?
lord, one certificate issued by the my lord, one certificate, my lord, issued by the president of the my lord, Jyoti Samobai, that my lord, one T-state, some Samobai committee was there, my lord. They have issued a certificate. That was not.
You are the owner of a T-state.
Hello.
You must be having some papers the tea board will give you. Or are you just a small tea grower?
And his my lord, T-state name is also mentioned, my lord. Boruki T-state. And
What
Bagan
is the area of the T-state?
And registration number is also mentioned.
What is the area of the T-state?
Area not mentioned, my lord.
It is not a T-state. Are you a small tea grower? Huh? Nothing is there in evidence. The court is very happy. Has been right.
Not even discussed, my lord.
Not discussed. So how can you discuss if you have submitted it?
It is, my lord, stated, lordship, if your lordship find, my lord, in paragraph 21 of the judgment, page 27, my lord. Page 27.
Paragraph 21 of the judgment.
Yes.
In the case, the claimant
Claimant-
testified that the husband was a retired teacher and owner of a tea estate. The claimant did not adduce any convincing evidence regarding income of her year. Therefore, in the absence of Iman, so and so, taking into account the year has been taken at 9,000 can be accepted as notional income. Then what is wrong?
But one hand, my lord, he admitted that I have testified that I am owner of a my lord, tea estate.
Who?
And
He's dead.
This is, my lord.
This is how can he testify?
My lord, it is claimant testified that this is was the owner of a tea estate.
You may tomorrow that anybody can say that he is the owner of Taj Mahal. That doesn't make him an owner unless you produce a document to that effect.
Income certificate was produced. And my lord,
What
bank
income
statement-
certificate did you produce?
My lord,
What income certificate did you produce?
income certificate, income from the my lord, tea estate.
Who gives? Small tea grower. I was telling you, na. He's a small tea grower.
That is why my lord,
Teo Sam Bagan, Nam Hol Bokura Iman, registration number Ukto Baganor, Pora, Teo Bosorikia, I Iman. And who had a person who adduced evidence?
claimant herself.
Nobody else. How did you prove this document? Tell me. Let us also be clever. How did you prove this document?
Exhibit 6 is the bank statement, my lord. The pension, he was receiving pension of rupees.
That to pension you will always get. Wife will get it.
My lord, half
Half.
pension, half.
No, one thing you may very well say. So 9,000, they could not have put it, and it would have been more than that, taking into account that his pension was there.
Yes, that is what. Exhibit 6 was. also
Or
not
Mr. N.K. Kolita, the learned counsel appearing on behalf of the appellant. This is an appeal filed under section 173 of the Motor Vehicles Act 1988, challenging the judgment and award dated 19/12/2024, passed in MSC case number 07 of the 2023. The instant appeal has been filed, being aggrieved by the inadequacy of the compensation so awarded by the learned tribunal. Tribunal to नाम तो दे दी सुना, Learned Motor Accidents Claims Tribunal, Dhemaji, huh? On the ground that notional income of rupees 9,000 was taken into consideration in spite of the fact that evidence was adduced to the effect that the deceased was getting a pension of rupees 33,175 per month. And in addition to that, a document was exhibited to the effect that the deceased was earning 4,50,000 per year. Full stop. The learned counsel submits that the learned tribunal had discarded this evidence merely by stating that there was no convincing documents, but without discussing these evidence. Taking into account the above, the instant appeal is admitted, call for the record, steps be taken upon the respondents by way of register as well as.
16.
When I'm referring speaking ground. Contributory negligence, same. But let's say, like a small, slightly different submission here in this case. Okay. In this case, the learned member, there's some sufficient material in this case, Lordship, so consider some contributory negligence. I'll take your Lordship to para number 7 and 8 of the judgment, Lordship. 7 and 8. Just to show that this plea could have. Para number 6, Lordship, on receipt of notices, all the opposite parties appeared and contested the case of the claimant by filing their respective written statements. Lordship, in this case, generally, Lordship, owner driver do not appear, but here they seem to have taken a stand, Lordship. The OP1 Lalan Rai, being the driver of the offender, has denied all the averments made in the claim petition. He has stated that on the day of the alleged accident, the offending truck loaded with cement was driven by him, and due to some mechanical defect, he stopped the vehicle near the Gargo Motors and was waiting for the owner. At about 10 p.m., the deceased came riding his motorcycle in a zigzag and negligent manner and hit the station truck coming in the wrong side. OP1 further denies the occupation and monthly income received, and further stated that he was holding driving license control also. Thus, in the next pair, the OP2 Rajiv Kolta, being the owner of the offending truck, has also submitted in the same manner. I said, my whole note, there's he of course did not appear in the witness box. But there's something unusually, the driver and owner did not come. They have taken their vehicle was that. That's the only ground for taking the plea of confusion. Let's say one or two points on the quantum.
Your vehicle was stationed.
That's what the driver said, Lordship. But charge sheet and other things they did not say. They said it's a collision between two vehicles.
And you did not get use evidence.
That's again same thing. No evidence. Lordship.
Then the problem arises, no?
But I thought these materials, maybe it's not me insurer, but the driver coming and say his vehicle was stationed.
But that is a pleading.
No evidence. He did not
And
come.
your evidence is also not there.
Nothing.
No pleading also.
We could have probably examined the driver himself, but that unfortunately. We could have examined the driver himself.
Not only that, you should have also pleaded. You didn't plead it contributory negligence. See your written statement, have a look.
No, it's not.
There's nothing. But then it is only on the ground of contributory negligence. Let us not dismiss your appeal, the second appeal in a day.
I think there are some points under quantum.
Quantum, what do you
Quantum
have?
Lordship. Lordship, in this case, his age was 22 years. And accident had occurred in the year 2015. At that point, he was supposed to be working with some firm. And at that time, notional income was not properly proved. The owner someone had come as a owner. He did not have any documents to prove that he was the owner. And it was taken as 10,000. That is one point. Secondly, there's a future prospect ought to have been 40%. It has been taken as 50%. And apart from loss of consortium, loss of love and affection, this is not payable 50,000. It's a small amount, but this once we pay
Loss of
for,
love and
provide for,
affection, loss of affection goes. Then this happened in the year 2017. 15. Then the loss of consortium, loss of estate should be less.
Yes.
It has to be how many persons were there? 3.
Actually, there were 4
Loss of
persons.
4.
The father has also been considered dependent. Father, mother, and
No, but loss of consortium, father will get it. So it will be 160.
that has been taken.
No, 176 they have taken.
I think they were 10%.
Loss of estate will be 15,000 because we have to apply the law then. Na? And then funeral expenses is also 15,000. Loss of future prospects is, how is it being done?
That instead of Lordship, 50% has been taken. It should have been 40%.
40%. And 10,000 is being taken.
Yes, Lordship, 10,000 has been taken.
10,000 is being taken, which comes to rupees 7,500 into 12 is 16. In addition to that, 50% is added is so and so. So this should be 40%.
This will be 40%.
We reduce this and we allow it. Matter over.
With regard to future prospect, the deceased was aged about 22 years,
So what? I
Invalid.
can't help it because you didn't have a salary thing. Na?
Yes, he was working as a supervisor in a PJ services, The owner of the PJ services, he was examined as CW3, He has appeared before the court. He has proved the salary certificate, He says that, since the last part of 2013, he was working as the supervisor of the firm, So if a part,
But was it a permanent job?
yes, since he says since the last part of 2013, he was working as a supervisor of his firm,
But was it a permanent job?
Yes,
Private jobs are not permanent jobs.
But he was continuously working and
He was 22 years at that time of it.
Did you produce the appointment letter?
Appointment letter was he have not produced, but a certificate. is
Giving a
used.
submission. You see, it is only when you have a permanent job. One is very careful. This is not a permanent job.
This PJ services is a firm, and that firm has employed, although this is not a government firm, but he was working since 2013, So my submission that, that is a permanent job,
No. You do one thing. And what about you saying about the loss of consortium?
Loss of consortium, there are 4 dependents, wife.
It will be 160.
Yes, that.
Funeral expenses 15,000.
Then
Loss of estate
that
15,000.
will come down.
Love and affection, no, not there. So therefore, if it is 16,200 is taken and taking it at 40% as the loss of future prospects, okay. Find it out. How much you are already getting 9% interest. That is also high.
Maybe
But income is rupees 10,000 per month, my lord.
They have taken, they have
Yes.
deducted and made it 7,500.
Yes, my lord, after deduction, my lord.
So that is okay. I'm not touching on 16,200. What am I touching on is on the future prospects. Make it 40%. And then funeral expenses 15,000, loss
That-
of consortium
that-
160, loss of estate 15,000, loss of love and affection 0. So then come to what it will, and then they will pay. That is his only grant.
pay the interest can be reduced a bit.
7.5. Come to an agreement. We'll take it up Monday. Come up with
Sally
this
make the
figure.
calculation.
Make the calculation and come to an agreement. Matter can be finished it off unless they're keeping it. This matter on Wednesday.
When do we
Lordship
come?
may
to-
dispose of-
Wednesday.
When is,
Or lordship may dispose of what lordship proposes. What lordship has proposed, my lord, lordship may dispose of.
And I'll dispose it of. Come to that, yeah. I'll finish it off on Wednesday.
I will do the calculations now, only,
You want it today?
if possible, my lord.
Other lawyers are, yeah. So let it, I have already taken up so many appeals, they're finishing it up.
because what is happening that my office has been attached, Lordship. So I'll be very happy for a release.
Okay, you
When
come
is
to
it?
the, yeah, I'll dispose it off. After some time, I'll around 4:45 to 5, this is the matter.
Wednesday,
No, we'll finish it off. You just, yeah. We'll just finish it off. You may not be there, but this is the order which I'm passing. I'll sit out here and pass that order. It's 15 minutes of this matter. This matter should not be there. Because one day, another day, this will go up. Make the interest at 7.5%.
my office is under attachment, Lordship.
Then finish it off and you deposit it within 6 weeks. You kindly come to the calculation, huh, Mr. Goswami?
The next week itself. The
No,
office is-
you-
office has been attached, Lordship.
No, I give you time to deposit within 6 weeks. We'll deposit.
17.
All right.
Yes.
So here the driver did not have a valid driving license. For the
Huh?
driver did not have a valid driving license. And the insurance company adduced evidence also, Lordship. He has a fake license.
Had a fake license. So the court had directed for pay and recovery.
Pay and recovery, Lordship.
So what is wrong?
So when there is violation of policy condition, why should the insurance company pay? It is the owner's duty.
Recover. Because the insurance was there. The vehicle was insured.
Okay, once the payment is made, Lordship, the recovery is very difficult, Lordship. That is the main problem.
So therefore, don't insure. Once you have a insurance, from the next date onwards, your agent, 1 month or 2 months prior to your vehicle getting insurance being over, your agents keeps on calling every person. That kindly get my vehicle insured, kindly get your vehicles, only 2 months is left, immediately, we'll give you 20% discount, immediately you do. You are very, very happy out there. But once you get that insurance done, thereafter nothing. So,
But what about the fault of the owner, Lordship?
Huh?
He knowingly allowed the vehicle to be driven by a driver who did not have a, not even valid, it is totally fake license.
how do we know?
Because the DTO report was there, Lordship. And in the-
DTO said later on. He didn't go to the DTO. Then what is wrong?
Lordship may kindly pass over the matter, Lordship, for today.
Chalo. That day I dismissed one petition like this. Counsel appearing on behalf of the appellant seeks for an accommodation, leaves the matter after 2 weeks. Online. I mean, this way.
Item 44, hearing under Order 41, Rule 11, CPC.
In this matter, Yona has asked me to, in this matter, Yona has directed me to submit the court fee with regard to counterclaim. Yona, I need some time because on that day only the execution took place and they everything was evicted from the premises. So, I need some time because the client
You have been evicted?
on that day itself, on that, execution to
Execution is completed.
on that day itself in the evening. Last of on night.
How many courts you lost? Both courts?
Contact.
Chalo. When do you want?
Next week, Your Honor.
Is the matter on again? 2nd of June? 2nd of June.
God bless you.
Stay matters, item 38.
Yok.
Item 38, stay matters.
None appears on behalf of the petitioner on call. Pusto. It is further seen that no steps have also been taken in pursuance to the order dated 2/4/2025. Considering the above, this court vacates the order dated 26/2016 by which the further proceedings of title suit number 6/2012 pending before the court of the learned civil judge Morigao was stayed. Pusto. The learned court of the civil judge Morigao shall proceed with the proceedings with title suit number 6/2012. First of the registry shall intimate the instant order before the learned trial court. First of, it is observed that if on the next date the petitioner is not represented, the instant proceedings shall be dismissed for non-prosecution. List this matter again on 6th of June 2025.
39,
Both the respondents are expired, but to get informed. So I may be allowed to file a substitution application. I will file by next week.
When
By next week. Next week, Lordship.
when they expired,
As per information, Lordship, respondent number 1 expired in February 2025 and respondent number 5, March 2025.
it has been brought to the attention of this court by Mr. R. Ali, the learned counsel appearing on behalf of the petitioner, that he has been duly informed that the respondent number 1 and 2 expired in the month of February and March 2025 respectively. First of taking into account that he submits that he may be permitted to take steps in this regard. First of list this matter again after 3 weeks, after 4 weeks.
40,
Pass earlier,
There is no interim order.
interim order is there, Lordship.
There, then you did not appear one day, so it has been vacated.
Not very early, both parties were absent, Lordship.
No, can't help
Kindly-
it. There is no interim order. How do I say past the earliest?
Just both the parties were absent on that.
I don't want, don't make me.
They expired, Lordship.
Who?
Respondent number 1 and 2.
Have you given the names of the legal representatives?
No, Lordship.
You have it?
Yes, Lordship.
Give it.
Lordship.
Kindly stay, card may be considered.
How do I do it? Take your steps immediately.
40,
Yes, what are you challenging?
My lord, here it is fixed for hearing on a stay, my lord. The present petitioners,
Mr. Mahmood, may I make it very clear? These applications under 227, in my opinion, first day, notice has been issued with a stay. The second day, if it comes before me, it is finished. This way or that way. So don't say only on the stay. It goes for a 6 on that day. Now tell me what you are challenging. Non-granting of an implement amendment application.
yes.
Now, what is it?
Now our submission in this, my lord, is ever that amendment should be granted liberally and
What was the time at which you
yes,
filed
that
that?
is, my lord, on the day of argument, it was argument stage, but my lord, for the interest of justice.
There's no interest of
Uh,
justice. Now let
so
us
there
see your
was-
petition.
There was no counterclaim which should have been submitted. but that
Amending
was-
the written statement.
My lord.
Counterclaim,
Yes,
Lordship.
a-
Written statement and
Only
counterclaim.
a part of.
And
a-
issue there, everything was framed, Lordship, and Honorable Apex Court judgment, Lordship, after issue, Lordship, no amendment.
No, amendment can be given, but
It is for counterclaim.
why?
Amendment can be granted at any stage before pronouncement of judgment. But thing is this, my lord, there was the thing, it was misstated the real fact. In WS Lordship may kindly see page 20.
At the stage of argument, Lordship.
That is true, that is true. But thing is this,
No, Mr. Mahmood, dismissed. Heard Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner, Mr. K. M. Majumdar
let
appears on
let
behalf of
me
the.
submit first.
No, Mr. Mahmood, not a single line also. That is why I looked into. You have not explained your due diligence also, why you could not file it earlier. I can't exercise 227 there.
No, that is there, my lord. For a moment, I. in fact,
That
your
everything is there, but
the
only thing
amendment
is how do I
petition, can you
exercise?
see the amendment petition, page 33.
I've looked into. No case.
Then let me give some time to satisfy your lordship in a better manner. Lordship.
I'll give you after 2 years time. but I'm vacating the interim order. Let the suit proceed, decided, thereupon the matter be listed by the registry.
The purpose of amendment is would be for infectious
So
preparation.
therefore, I'm dismissing it. You can't do that. And if I reject it, you cannot file an application for amendment before the High Court, in the appellate court. You still have a chance to amend, but that is gone. Remember that also.
That I understand, but thing is, this was due to mistake of lawyers, participants, Sabha, my lord. They did not make the counterclaim instead of there is a good ground of counterclaim.
You file a
So
suit.
let me give at least 2 weeks time so that I may, there are so many judgments I have. Already those.
All these judgments go so before the Supreme Court. Supreme Court may help you under what? Supreme Court may help you, Mr. Mahmood, before the Supreme Court may help you under 142. I cannot under 227. 227 is limited in that.
Everybody cannot go to Supreme Court.
Heard Mr. M.
Mr.
Mahmood, the
Orwell.
learned counsel, appearing on behalf of the petitioner, Mr. K. M. Majumdar, appears for
Respondent lordship.
all the respondents. How many respondents?
One respondent.
The instant application, the supervisory jurisdiction of this court has been invoked, challenging the order dated 10/7/2024, passed by the learned court of learned court of the Civil Judge Senior Division Buxa, hereinafter referred to as the learned trial court in midday case number 09/2024 arising out of title suit number 02/2022, whereby the application filed under Order 6, Rule 17 of the Code of Civil Procedure 1908, for short the code, was rejected. Full stop. It is seen from the records that the said order, impugn order, was passed. And it is seen from the records that at the when the suit was at the stage of arguments, an application was filed by the petitioners who were the defendants in the suit, seeking amendment of the written statement as well as also
Counterclaim.
the counterclaim. Full stop. The said application has been registered, has been enclosed to the instant petition as annexure 3 to the as annexure 3. A perusal of the said petition nowhere explains anything as regards the due diligence, which is nowhere states anything pertaining to why the petitioners could not file the said amendment application prior to the trial having commenced. It is also relevant to take note of that the petitioners herein continued to proceed with the suit, and only at the stage of arguments this amendment application was filed. Under such circumstances, this court does not find any illegality in the order being passed by the learned trial court in rejecting the amendment application, for which the instant petition stands dismissed. This court further takes note of that by an order dated 31/7/2024, the further proceedings of title suit number 02/2022 pending in the court of the Civil Judge Senior Division Buxa at Musalpur, BTR, Assam was stayed. The said stay order is vacated. Full stop. Taking into account that both the parties are duly represented, they are directed to appear before the learned trial court on 16th of June 2025 for further proceedings of the suit.
31.
Yes, who wants to go where? What happened?
It is a transfer petition, lordship.
What about the service?
Go to the district, huh? Service.
Issue
area
that there were
doesn't
no steps taken. Service is not received. Service you are not taking.
That's the This
I'm
thing was
vacating the interim order.
as the petitioner is,
Interim order is vacated.
Lordship, the petitioner
We
is
have not
having
taken
baby of 2 months. The petitioner is having baby of 2 months.
Are
Lordship.
you?
No, no, the petitioner.
I'm asking, are you? No. Is your Mr. BJ Mukherjee having? No. You are supposed to take the steps, not her. Then you have taken the responsibility of taking up this matter. It is your responsibility. When there is a direction to take steps, is it directed to that petitioner to come over out here and take steps? Do you mean to say that?
Taken steps through registered post, Lordship.
You were asked to take steps by way of registered as well as usual. You were asked to take steps by way of dusty. And these are the reasons why I have stated. Nothing. Help it. Dismissed. We have not taken steps. Interim order vacated. It is seen that no steps have been taken. The counsel appearing on behalf of the petitioner seeks a final opportunity to take steps upon the respondent by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. Taking into account the above, the matter is directed to be listed on 23rd of June 2025. The interim order passed on 27/1/2025 stands extended. It is observed that if no steps is taken by way of dusty on the next occasion, this court would not extend the interim order.
May it please your lordship, my lord. My lord, here, my lord, the petitioner is the defendant number 1. And my lord, plaintiff respondent file application for amendment, my lord. This is the order, my lord, at page 56, whereby the amendment was allowed. Against this amendment, we approach this honorable court, challenging his order dated, my lord, 12/3/2025 at page 56. My lord, kindly see the relevant portion of page 58. Page 58, my lord, from the middle, my lord, peruse. It appears that the plaintiff petitioner wants to insert paragraph 8(1), almost repeating the same facts, and the plaintiff is one of the 4 legal heirs of Girikanta Saikia, and as such he is entitled to 1/4 share of the property of Girikanta Saikia as the right of inheritance. In paragraph 8.2, it appears that plaintiff, apart from repeating the facts that she is entitled 1/4 share as specifically sought out the area of land which she claims for each schedule A, B1, C1, D1, and E. And in paragraph 8.3, the petitioner prayed for making Dilip Kalita Latbandal the party. Now, my lord, while allowing the amendment as sought for 8(1) and 8(2), although there was a repetition without considering that 8 Latbandal that sought to be made party, that was rejected. Now, our, my lord, ground of challenge.
What are you challenging? You are challenging the amendment.
On the ground, page 24 in the plain, kindly see, my lord. That is already there, 1/4 share C1. He is my elder sister, and other 2 sisters, we are now 4. Parents are expired.
Now after marriage, in the marriage, we given all them the property. Again, after marriage, Malad, she wants her share of the land. That is another thing. Now thing is that page 24, kindly see Malad in the plaint.
First of all, what is the stage?
Stage Malad, after framing an issue, they filed this amendment and this Malad, again, now we have been directed to file written statement of Malad.
You don't want to file.
Malad, we have challenged this on the ground whether Malad order 6 rule 17
No, my
power of
only
discussion.
Only question is you don't want to file. File.
Malad, before that, just to submission, Malad. Malad, here whether the power under order 6 rule 17 allowing amendment being the discretionary power, whether the discussion has been at all exercised in this case, whereby the court below has said that these are mere repetition. This is already there. If that is there, whether purpose of amendment, my lord, in my humble submission, purpose of amendment to add or to amend what is not there or subsequent thereto. My lord, if something is there, whether for the purpose of repeating the statements or restating the statement in the plain, that power can be exercised, my lord, this is the question. Now, my lord, only, my lord, 2 or 3 judgments, my lord. Just I place, my lord, 3 judgments, my lord. You also kindly have a look.
You have stayed the suit.
My lord.
You don't want to file the written statement. Don't file the written statement. Let him proceed with the suit. Don't file. You don't want to file the additional written statement.
My lord, now that lordship may kindly answer that, my lord, or in the deal with the whether the power for amendment under order 6 rule 7 also include for repeating the statement what is there.
The court paragraph at page 59 categorically says that it appears that those paragraphs are elucidation of the already stated facts in the original plaint.
My lord.
So they want to make it more clarificatory.
But the same court itself said, my lord, this is
Why,
a mere
Mr.
repetition.
Bikedas, why have you advised your client to file this and thereby delayed the suit by how much?
No, my lord, this is very recent. Within this month only 10/4, my lord, that was the order, and stay on my lord 34.
Well, fantastic.
34.
12-3 order.
My lord. No, my
12-3.
lord. Yes, you should notice, my lord, thereafter 34.
So 90 days is going to be over on 6.
Yes. And next date, although there is a stay, next date fixed on 19/6, my lord, by the court below.
So file your written statement on that.
My lord, I leave it to your lordship. Otherwise, judgments, losses were returned, my lord. There.
Mr. Bikedas, hearing on behalf of the petitioner, Mr. M. Datta appears on behalf of the respondents. The supervisory jurisdiction of this court has been invoked to challenge the order dated 12/3/2025 passed in MJ case number 57/2024, whereby an application under Order 6 Rule 17 of the Code of Civil Procedure was partly allowed by the learned court of the Civil Judge Senior Division Morigaon, or short the learned trial court. Mr. Bikedas, the learned counsel appearing on behalf of the petitioner. Now, this court have duly perused the impugned order dated 12/3/2025, whereby the learned trial court, taking into account that the statements which have been sought to be inserted in the plaint at paragraph number 8 Roman 1 and 8 Roman 2, as well as the reliefs which have been sought to be added, have allowed the said application seeking amendment, and further rejected the amendment insofar as insertion of paragraph 8 Roman 3 to the plaint. Full stop. This court further have taken note of the reasons so assigned by the learned trial court and taking into account that the trial have not commenced. It is therefore the opinion of this court that the jurisdiction so exercised by the learned trial court, learned trial court do not call for any interference. Full stop. This court further also takes note of that on by an order dated 30/4/2025, the further proceedings of title suit number 14/2022 have been was stayed. Full stop. Taking into account that both the parties in the suit are duly represented before this court, they are directed to appear before the learned trial court on 19/6/2025 for further proceedings of title suit number 14/2022. It is observed that while computing the period permitted, the period for granting, while computing the period for filing of the written statement against the filing of the additional written statement, the learned trial court shall further take into consideration that for the period from 30/4/2025 till date, there was a stay.
For orders, item 18.
And for respondent number two, Lordship. Respondent number one expired.
Who is for number one?
One is the brother of the deceased.
Who are you?
I'm sister-in-law of the deceased.
Huh?
Widowed sister-in-law of the deceased.
Respondent number one had died.
Right.
Respondent number two is the wife of?
The brother of the deceased.
And who is the deceased?
This is the brother of the respondent number one.
Who is Noreshwar Mohanto? How is the deceased connected with you?
Two, Lordship. One expired, Lordship. One is the brother of the deceased. Two is the widowed sister-in-law of the deceased. So respondent number one expired. Two remains, Lordship. And
Who is
substitution,
three?
Lordship.
Three is who? Owner?
Three is the owner, Lordship.
And what is the amount granted? 6,16,000. What is the ground of appeal?
Lordship, memo not furnished to me. Memo not furnished to me, Lordship.
Memo not furnished to you. Chalo. Where is Mr. K.K. Bhatto? Nowhere. Is anybody appearing for MS United Insurance? No. Are you a counsel for United India Insurance?
Yes, ma'am. I will inform my lord.
Huh?
I will inform.
Take whatever steps is required.
Sure.
Okay. Ms. So and so who appears on behalf of the who is also in the panel of lawyers appearing on behalf of the appellant insurance company, submits that she would instruct the appellant to take appropriate steps. List this matter again on
In the month of June.
9th of June, 2025.
Oh, bless you.
19,
Lordship, right order dated 21/4/2023, we are directed to take steps for substituting the respondent number 5, 8, and 9. Lordship, they were the performer defendants.
Yeah, performer.
Yeah, they were the performer in the title suit, in the title appeal, and also in this RSA.
So we can remove it.
Yeah.
It has been submitted by the learned counsel appearing on behalf of the appellant. The respondent number 5, 8, and 9 were performer defendants. And as such, there is no requirement for substitution. Taking into account the above, this court duly taking into account the above, this court duly brings the said aspect of the matter on record. This court duly this court strikes out the name of the respondent number 5, 8, and 9. It is further seen that steps are otherwise, it is further seen that the services are otherwise complete. However, it is also seen that the LCR of title suit number 363/2010 is not yet received. List the matter for hearing in the usual course. The registry shall take effective steps for getting the records of LCR of title suit number, for requisitioning of the records of LCR of title suit number 363/2010 at the earliest, and thereupon list the matter for hearing in the usual course. Full. Liberty is given to both the parties to file application for early hearing after ascertaining that the records of TS number 363/2010 has been received by the registry.
20,
Well, in this matter, service on respondent number 1 is not complete.
You have not taken steps.
We had, it is not reflected though. 8321 and 2321, we have taken it's. That was in the COVID time, we do not have the hard copies for that. For the printout, we have got, We also verified with the filing section. Respondent number 2 is appearing here. For 1, we may take test. Yes.
You are paying for?
My lord, my name is not reflected. All the last order is reflected my name. So maybe the state, I'm repaying for the.
Why there are two insurance companies?
But there is a 2 vehicles, sir. 2 vehicles. Head-on collision.
And there is a direction to pay to both.
No, but I filed in my lord 3 cases. There is a 7 cases. He filed in 4 cases on behalf of the claimants. 1 case is dismissed. Against the dismissal case, I have not filed the appeal by the United Insurance Company. But other 3 cases I filed and stay was granted. But
Then why do you need the New India insurance?
My lord, out of the accident, 4 cases were filed. 4 different parties, all death cases. All patients had died. So on that 4 cases were filed. Eventually, the learned tribunal came to a finding that there was a contributory negligence and the driver of the wagoner had contributed to the right. This point was agitated by all. in all the four appeals, and we said no, because this will have an impact on all. Therefore, we are praying for direction, the driver of the offending vehicle, the truck. Now, we say offending vehicle is our version, but also the charge sheet and all. They also say that the truck is the offending vehicle. This point was not taken into consideration.
That is issued with the respondent number one.
One.
Yeah. That is.
Only on
challenge.
that count.
We have
nothing more.
challenge.
Service upon the respondent number one being not complete, list the matter after completion of service.
My lord.
My name will be reflected.
Mr. R.C.
That's
name
one
of
number
the,
two.
Mr. R.C. Paul will be reflected in the court list.
Right.
21.
Mr. Bonig, you take fresh steps.
21.
It seems that the steps, the service upon the respondent number one is not complete. Whereas Mr. R.C. Paul appears for the respondent number two. Full stop. The petitioner is directed to take fresh steps upon the respondent number one by way of registered as well as usual within 7 days from today. In addition to that, the petitioner is also directed to effect service upon the respondent number one by way of dusty routed through the registry of the spot and file an affidavit of service on or before the next date. List the matter again on 23rd of June 2025. The registry shall indicate the name of Mr. R.C. Paul appearing on behalf of the respondent number two.
21.
The service in so
Service
far
is
as,
not complete, lordship. Our respondent
who is
number
respondent number 6 and 7?
6 and 7, we want to take by Dusty, lordship.
Who is respondent number 6 and 7?
6 and 7. Six is the owner and 7 is the driver, lordship.
And why you are challenging? Your challenge is on what? Quantum?
Lordship, this is a cross objection. Original is on the claimant.
Huh?
The original appeal is on the claimant, lordship. We have filed.
You are filing an appeal.
Yes, lordship.
Why you are challenging the judgment? On the quantum?
Yeah. Could not go for the.
Mr. Ayat Talukdar.
As far the appeal is concerned, my lord, as per the scheme of compensatory department scheme, this appeal is not tenable in law. As this is the appeal is not tenable in law. This is their cross appeal. I filed the present of the respondent is.
You are the appellant.
I am an appellant. I filed the appeal for enhancement of the award, my lord. Now the respondent insurance company filed a cross appeal along with a delay application of 816 days. So delay is not yet condoned.
That's your main ground of cross objection.
No. So
driving license.
the tribunal, what did the tribunal do?
My lord, tribunal awarded a sum of rupees 15 lakh something in favor of the claimant, my lord.
And directed
To pay by the insurance company, the present respondent, my lord.
and not to recover.
Not to recover.
So then why do you need respondent number 6 and 7?
They are not required because I have struck out this respondent number 2 and 3, my lord.
Then why you want the 6 and 7?
Lordship, as per lordship.
You want to delay it.
Point number Z, lordship, we are taking a ground of driving license not valid, issued by DTO.
But did you take that point before the learned trial court?
No such point raised. No such point raised. No such point raised.
Yeah.
So once chance may be given because we have to take by Dusty only. By way of Dusty.
They are not required, my lord, because the
Anyways,
liability.
no, it's okay. Have you filed objection against that application?
Yes, I have already filed my objection.
We dismiss your petition, then 6 and 7 is nowhere there. Not necessary.
Yes.
Matter over. So your cross objection goes for a 6.
Yes, ma'am.
Delay of 857 days. So his only appeal remains.
No, proper explanation was given by also, my lord.
846 days.
840, no proper explanation was given also.
And they appeared in the appeal
Yes, they appear in the appeal also. The
when the notice was issued.
notice was issued by the appellant.
So one chance may be given, lordship.
For
You
what?
may strike out the name of 6 and 7. I have no problem in that.
No, we dismiss your petition only.
Whichever
Cross
one
objection
section be granted,
finished.
Because I could not go through the file properly, Lordship.
Okay, the learned
lot to-
counsel appearing on behalf of the appellant cross objection for the respondent number. Respondent number?
On my lord.
Respondent number 1 submits that he has not gone through the file, so some accommodation. List this matter again on 9th of June 2025.
Obliged, Lordship.
22.
Read this.
Well, there is a delay of 1583 days in preferring the application under order 22 rule 3 seeking substitution of the sole respondent.
Sole
Respondent.
respondent, it is not 22/3, it will be 22/4.
It should be 23 4 months.
Then why so such a delay?
My lord, earlier it was filed by the previous engaged counsel that was dismissed for default. And thereafter we have been handed over the brief and we have filed afresh. The suit has been abated and along with this, we have filed setting aside of abatement and substitution of the
Dismissed for default.
for default earlier.
So
And
why
we have-
didn't you restore that?
My lord, that was dismissed for default long back and we have not been informed.
Huh?
We have not been informed by the earlier engaged counsel.
So you have filed a case against that council?
Fresh
You
application.
filed a case against that bar council before the bar
No,
council?
no.
No, don't make allegation against the council.
And
You
it
file
was
an
returned-
application, then only you have filed objection.
No, Lordship.
You don't want to file objection.
And for quantity, and I have no objection, Lordship, regarding this. For substitution, I have no objection, Lordship.
Did you? When do you file to do? File to do? Matter pertains to what?
My lord, rejection of order 7 rule 11 application.
Huh?
Order 7 rule 11 application rejection. I'm the defendant therein. There are.
What is your ground on order 7 rule
My lord,
11?
there are 3-4 sets of litigations between the parties. And
Huh?
3-4 sets of litigation, previous litigation. The plaintiff has already filed writ petition before this honorable court.
On the ground of res judicata?
Res judicata, my lord.
So res judicata cannot be a ground on the order 7.
Res judicata, as well as they have not, my lord, they have not made the government as a party.
Government not made a party, that is a case of cannot be a non, yeah. So-
My lord, that is true. And the other ground we have taken. My lord, there is no cause of action for filing this suit.
No cause of action is not a ground.
Because this suit property doesn't belongs to the plaintiff and he only filed the suit for
There
recovery.
is no cause of action is not a ground. Whether the plain discloses a cause of action is or not, it does. Matter over. Chalo,
That
we
is
do
what
one
our
thing.
contention, my lord.
we allow this application, dismiss his petition.
But you could see, kindly see the order passed by the.
Not necessary. This suit has been stayed for a long time.
Well, there is no ground. There is the writ petition, the plaintiff.
Mr. Counsel, writ petition is there, whatever may be there, these are questions which is your defense.
My lord, we have taken the defense in our.
So can this defense be taken at the time of for deciding an order 7 rule 11? Tell me. Let us change the law for you. Then লেখক এই দুইখন একেলগে লাগিব CRP IA দুখন IA তিনিখন. The three applications are taken up together. Which pertains to substitution of the legal representative of the sole respondent,
Yes, Lord.
who expired on
3/8/2018.
3/8/2018. Full stop. The learned counsel who appears on behalf of the opposite parties to the instant application submits that he has no objection in the condonation of the delay, setting aside of the abatement, as well as the substitution of the applicants as respondents to the accompanying revisional proceedings. Full stop. Considering the above, all the three applications are allowed, thereby condoning the delay, comma, substitution, setting aside of the abatement, as well as substitution of the respondent opposite party number 2 and 3 to the accompanying application. Chalo, the main petition. The instant petition is being taken up, taking into account that for the last 1 decade, the instant proceedings have been, the suit proceedings have been stayed. Full stop. It is seen that the present proceedings have been filed challenging an order dated 9/7/2015, by which an application filed under Order 7, Rule 11A and D of the Code of Civil Procedure 1908 for rejection of the plaint was rejected by the court of the civil judge Lakhimpur at North Lakhimpur, for short, the learned trial court. Full stop. The grounds taken in the application for rejection of the plaint are: number A, that the plaintiff have not disclosed in his plaint that there were various other litigations for which the plaintiff could not have filed the suit. Number 2, and accordingly, could not file the suit. And accordingly, there were various other litigations, and as such, the principle of, on the basis of the principle of res judicata, the plaintiff could not have filed the suit. Number 2, the second ground,
Cause of action, now could discuss.
the second ground taken is that the suit so filed did not, then there was no cause of action for filing of the suit by the plaintiff. Third ground, 3,
These two,
you said something more?
well, this, plot, the plaintiff is not the owner of this plot of land. There's a question.
The third ground so taken is that the plaintiff is not the owner of the suit property.
And government
Full stop.
was not a made party. Government was not a party.
No. And the government was not made a party in the said suit. Full stop. Let this court analyze the 3 grounds which have been taken. Full stop. The first The first ground so taken cannot be a subject matter of a proceedings under Order 7, Rule 11, taking into account that the question of res judicata cannot be decided at the stage of Order 7, Rule 11. The second ground so taken, that the plaintiff has no cause of action, cannot also be a ground for rejection of the plaint, inasmuch as what the court is required to look into at the while deciding an application under Order 7, Rule 11, as to whether the plaint, on a reading of the plaint, as to whether upon reading of a plaint it discloses the cause of action. Full stop. This is very different from what is the case of the petitioner herein, who are the defendants in the suit. the question of there being no cause of action can only be decided at the trial of the suit. Number three, the third ground which is being taken is that the government is not a party, has not been made a party, and the plaintiff is not the owner of the suit land. Full stop. The question as to whether the government is a party in the suit or the suit should fail on account of non-joinder of necessary party is a question which can be only decided by the learned trial court after the evidence is adduced at the trial of the suit. Full stop. Further, the question as to whether the petitioner is the plaintiff is the owner of the property or not is a question of fact which cannot be decided at the stage of Order 7, Rule 11. Considering the above, this court finds no merit in the instant application, for which the instant application stands dismissed with a cost of 5,000 into 10, 50,000.
What's the account of the plaintiff petitioner that is delayed?
Why?
Well,
10 years.
This
Suit
application,
has been stayed.
this application was filed in 2023.
That's a different thing, but your petition, you are reviving these proceedings. You should have been happy and fight out there before the trial court. Okay, you should, with the cost of rupees 11,000.
23.
Deposited by the respondents before the learned trial court on the next date so fixed herein after, herein below.
Date may be fixed perhaps.
Full stop. Taking into account that both the parties are now duly represented, they are directed to appear before the learned trial court on 16/6/2025. Full stop. On the same date, the applicants, the opposite parties herein is granted the liberty to file appropriate application seeking substitution, taking into account that all this while the suit was stayed by this court.
23.
Service is complete, LCR has come.
Service being complete and the LCA having been received, list the matter for hearing in the usual course. Liberty given to both the parties to file appropriate application for early hearing.
24.
Completed and respondent 1 and 2, they had appeared.
What is the case?
Case is, Lord Lordship, the petitioner filed a ejectment suit under the Rent Control Act for the ejectment of the defendant. So that suit was, and in the suit, Your Lordship, an application was filed on Order 26 by the petitioner plaintiff Lordship for the commissioner. The learned trial court passed an order that this petition under Order 26 will be considered after completion of the DW. So when the DW finished, again the petitioner plaintiff placed that the petition under Order 26 is pending, that should be decided. Then the court passed the order that it will be decided at the time of lighting the judgment. And the matter was fixed for argument. On that day also, it was brought to the notice of the court that petition under 26, Order 26 is pending. And thereafter, Lordship, the suit was dismissed. Then title appeal was filed. In the title appeal, Your Lordship, an application was filed under Order 41, Rule 27 of the CPC law for giving additional evidence. In the meantime, what happened about all those are the documents which are intended to brought on record, all are the subsequent documents filed after the filing of the suit laws. And earlier, there was a 145 CRPC proceeding between the parties, in which already the suit position of the DL was declared in my favor, petitioner favor. After having the local inquiry by measurement of the land, by the circle officer, by the town committee, all of them reported that the owner of the suit land is the petitioner plaintiff.
Where is the order, order of rejection of your order 41 rule 27?
116.
11?
Director print. London Appellate Court decided the application under Order 41 Rule 27 before delivery of the judgment, which is not permissible. It is to be considered at the time of hearing of the appeal.
Heard Mr. S.P. Roy, the learned counsel appearing on behalf of the petitioner. Mr.
Wasim Haq on
So
behalf
and
of
so
Mr.
appears
Isam
who
Khan.
appears on behalf of the respondents. Pusto. This is an application filed under Article 227 of the Constitution challenging the order dated 18/11/2024 passed by the learned court of the Civil Judge Senior Division Lakhimpur at North Lakhimpur, by which the application filed under Order 41 Rule 27 read with Section 151 being petition number 1408/2024 arising out of title appeal number 09/2024 was rejected. First, the learned counsel appearing on behalf of the petitioner have drawn the attention of this court to the judgment of the Supreme Court in the case of Union of India versus Ibrahimuddin, reported in 2012, 8 SCC, page
Para 41, relevant.
page
Page lordship.
48,
Yes,
paragraph 51.
41.
No, paragraph 51.
In my citation.
That is a different paragraph 41. Paragraph
In
51.
HCC, it will be
Paragraph
51.
51 and 52 of the said judgment to submit and submits that the learned first appellate court had decided the application under Order 41, Rule 27 at a stage before taking up the appeal for final disposal. Full stop. This court have also further taken note of the impugned order, wherein it is seen that the learned first appellate court had decided the application under Order 41, Rule 27 of the code prior to deciding the appeal. First, it is further seen from a perusal of paragraph number 51. Not 51. Paragraph number 49. This court duly takes note of the paragraph 49, 50, 51, and 52 of the judgment of the Supreme Court in the case of in the case of Ibrahimuddin Supra, wherein the Supreme Court makes it very clear that an application for taking additional evidence on record at an appellate stage, even if filed during the pendency of the appeal, is to be heard at the time of final hearing of the appeal at the stage when, after appreciating of the evidence on record, the court reaches the conclusion that the additional evidence is required to be taken on record in order to pronounce the judgment or for any other substantial cause. Full stop. Was the appeal heard earlier?
Appeal, it was heard. Partly.
What is this partly? It has been fixed
In
for
one day
judgment.
It was heard,
It was fixed for judgment.
judgment.
Then,
Thereafter, I filed the pigeon petition, so further proceeding has been stayed.
you filed this order 41 rule 27 after the arguments.
Argument was not completed, Lordship. Partly it was taken.
Then why is it fixed for arguments, judgment?
The judgment, Lordship, by rejecting my petition, it was without hearing, it was fixed for judgment.
But without hearing, did you appear in North Lakhimpur?
Yes. On the date I appeared, the plaintiff, appellant appeared.
Huh?
It is plaintiff, Lordship.
Ah.
Huh? We filed this application, Lordship.
When did you file this application?
Yes. 2/8. 2/8/23.
2/8?
24, sorry. 2/8/20.
Full stop. Full stop. Taking into account the above, this court therefore restores the application filed being petition number 1408/2024 to the file of the learned court of the file of title appeal number 09/2024. And file of the court of the learned first appellate court, that is the court of the civil judge senior division Lakhimpur, and further directs that the said application being petition number 1408/2024 be considered at the time of considered in terms with paragraph number 52 of the judgment of the Supreme Court in the case of Ibrahimuddin Supra. Full stop. This court further takes note of that while deciding the said further takes note of that while deciding the said application, while deciding the said appeal, along with the application under order 41 rule 27, the learned first appellate court shall decide so without being influenced by the order dated 18/11/2024. Full stop. Further to that, this court vacates the order dated 29/11/2024 by which the further proceedings of title appeal number 09/2024 was stayed and directs both the parties to appear before the learned first appellate court on 23rd of June 2025 for further proceedings of the appeal. Like, worship.
25.
Who is 4 and 5? Four and 5? Oh, madam, you are the appellant. You have to tell me who is 4 and 5.
My lordship, 4 and 5 is the owner driver, Puneet Mesh and Bharat Prasad Mishra. The
Okay.
notice has not been served upon them because at the address there is no such person.
Okay, who is 4 and 5?
It's the
I don't need the names. Are they driver or an owner? Okay, who are you?
my lordship.
Who are you? Are you the claimant or the insurance?
Assurance.
Assurance. So, is there any direction to pay and recover?
No.
It is only a question of quantum. The challenge
Yes,
is on
yes,
the
ma'am.
quantum.
My lord.
So we remove 4 and 5.
Yes, ma'am. One of my submission made, madam. This matter on the first day, notice was issued, LCR was called for, and the accident was happened in 2014. And in the award dated, my lord, the honorable tribunal, my lord, directed to pay the amount within 30 days, ma'am. But it is almost 1 year, my lord.
Okay.
There is no stay.
Item
also.
number 25.
Five.
Na? Is there stay?
No stay. My lord.
No stay.
No stay.
Okay. Uh, It is seen that the instant appeal has been filed by the appellant, who is the insurer of the vehicle, solely on the ground of the quantum. Full stop. Under such circumstances, it is the opinion of the court that the presence of the respondent number 4 and 5 is not required. Accordingly, the names of the respondent number 4 and 5 is struck off.
In the last order 18/9/24, my lordship, the respondent number 5 has been mentioned as United India Insurance, but it was supposed to be respondent 6, United India. One of the respondents has not been mentioned.
There's a problem in system, my lord. I respond what I file local number for 1, 2, 3, but in the system it is not shown.
Okay. So you are paying for 1, 2, and 3.
Yeah, 1, 2, and 3, my lord.
4 and 5.
4 and 5 means.
Your challenge is only on the quantum,
Yes, ma'am.
nothing else.
No, my lordship.
Are you sure?
That's as far as I know, but
It's only on the quantum.
There is another ground they are challenging.
What ground?
Regarding license of.
There the problem arises.
Yes,
No, why
my
you are not making that?
No, but my lord, the offending vehicle is the dumper, and it is hit the motorcycle from the back side. And there is no pay and recovery on the offending, they are not made contributing negligence plea in the trial court as well as here, my lord. The point is not taken in the trial court also, here also, my lord. And I am pillion rider. I was not driver, man.
Okay. So there is no challenge.
No challenge. Incident was happened solely responsible by the dumper truck money.
Which was the vehicle in question? Which was the accident occurred? Dumper, what is the number?
Dumper.
AS-23.
AS-23 SC 6837. Tipper dumper, phase 41.
Okay. And again, the owner and driver will be required. Driver will be required. Link Mac and Gusto. So how do you affect service upon 4 and 5?
Certain the correct address and the companies.
Now, if you cannot stop. So it is seen that the service upon the respondent number 4 and 5 is not complete. Full stop. It is further seen that from the not complete on account of incorrect address. Full stop. The learned counsel appearing on behalf of the appellant is to ascertain the address and takes fresh steps upon the respondent numbers 4 and 5 on or before 16th of June 2025. Failure to take such steps by way of registered as well as usual on or before the said date, the matter be again placed before this court. Mr. So-and-so, who appears on behalf of the respondent numbers 1, 2, and 3, submits that in spite of there being no stay order, the respondent authority, the appellant insurance company have not made any payment before the registry, before the tribunal as directed by the impugned judgment and award. Full stop. This court takes note of the provisions of Order 41, Rule 5 of the Code of Civil Procedure 1908, which categorically stipulates that mere filing of an appeal would not amount to stay of the judgment and decree. So applying the same principle, this court observes that because of the fact that the appeal has been admitted, it shall not stop the learned tribunal to proceed with the execution of the judgment and award passed by the learned trial court, by the tribunal. First of, in addition to that, liberty is also given to the respondent numbers, the claimants, that is the respondent numbers 1, 2, and 3, to take effective steps under the various other provisions of law.
Probably driver owner did not contest in the trial court also.
Oh, they got this. No, they just stay. They're subject to deposit of 50%.
That
no.
order I don't have my. It is not reflected in the system also, madam.
No, they just stay. No, he shall take fresh steps by June. Full stop. Mr. So-and-so, who represents the respondent numbers 1, 2, and 3, submits that the appellant insurance company have not deposited the amount in spite of. Are you saying that you cannot say that?
No, I have not verified, madam.
So you are certain and then file an I.
Yes, madam. Madam, may I point out one thing, madam? In the award, paragraph 4, judgment and award, respondent number 5 and 6 did not appear. They did not contest in the trial court also. Driver and Amma.
You see, I have to give them some such because they have taken that ground that they didn't have a valid license. In ground number 2.
Motorcycle rider did not have the valid license.
No, they say Pulin Mech did not have. This is their statement in their grounds of objection. The respond number 4. Next.
26.
Time is needed to take process step with proper address, my lord, on respond number 6, my lord.
Respond number 6.
Yes, my lord. He is the owner of the vehicle, my lord.
You are the.
I'm the
appellant.
insurance company, my lord. Insurance
And
company.
what is the ground?
My lord, actually, the policy is in question, my lord. Insurance policy is in question, my lord.
Lordship, I am appearing for respondent 1 to 5, Lordship. And after receiving the LCR, this court will decide the stay petition, Lordship. That is fixed today, Lordship. Stay petition is pending, Lordship, before this honorable court. After
This may be heard at the time of hearing, my lord.
No.
So LCR
It's already that
received, my
order
lord.
is there.
Your stay as in.
No, stay is not there, Lordship. After receiving the LCR, what will be here? Order is there.
But there is no stay.
No, Lordship. Stay petition, the web file, but they have not.
Last order.
Stay notice has not been issued.
Yes, my lord. Last order is there, my lord.
Article 6/12/2024, it is.
You are not pressing the stay?
No, my lord,
Are you pressing the stay or not?
no, no, my lord.
The learned counsel appearing on behalf of the appellant insurance company submits that she is not pressing the application for stay of the judgment and award dated 30/6/2016. Full stop. Accordingly, the instant application stands dismissed on withdrawal. Full stop. Taking into account the above, this court further observes that it shall be open to the claimants to take appropriate steps before the tribunal seeking
Lordship,
execution.
that is the problem, Lordship. The record has been already received by this court, Lordship. So if we have to take any steps in that LCR record, we have to proceed with the Bakijai or the
No.
execution.
You take it there. You don't go for Bakijai. You know what to do. She's given the liberty to take steps before the year seeking execution of the judgment and award dated so and so before the tribunal. Full stop.
Obliged.
Yes, my lord.
And also under the appropriate provisions. There's a insurance regulatory act and all by which you can do that. If they don't deposit out there, they will issue notice and then cancel their license. Take that. They will
Obliged.
immediately. Expenses. Main case con steps to lobo na. Main case, what did they pass the order? Main case? We take first steps, na? As regards respond number 6, you want to take
Owner,
first
my
step.
lord, owner, my lord.
Huh?
Owner of the,
Necessary party, my lord, owner.
owner of the vehicle, response.
As we respond number 6 mo kolu niki? Nai koni? Okay. Ms. So-and-so, who's appearing on behalf of the appellant, submits that fresh steps may be taken, may be permitted to be taken against the respond number 6. Full stop. Accordingly, this court directs the respondent and the appellant to take fresh steps by way of registered as well as usual upon the respondent number 6 within 3 days.
Obliged.
27.
What is this?
Your Lordship, already service is complete.
For IA for
Delay condonation,
How much?
delay of 43 days, Your Lordship.
there is an application file and the file seeking condonation of delay of 43 days in preferring the accompanying appeal against the judgment and award dated 10/3/2023 passed by the learned member Motor Accidents Claims Tribunal number 1 Kamrup Metro at Guwahati in MAC case number 193 of 2017. Full stop. This court have duly perused the reasons so assigned in paragraph number 2 and paragraph number 2. Full stop. The reasons so assigned in the opinion of this court comes within the ambit of sufficient cause and accordingly the delay of 43 days is condoned. The registry is directed to register the accompanying appeal and list the matter for in the stage of order 41 rule 11.
Obliged.
28.
What is this?
Transfer petition, matrimonial matter, my lord. I appear for the husband for the first time, I appear in my lord. I have a submission, my lord. They are asking for a stay of the proceeding here. Your lordship didn't speak, that may be passed. And the matter goes to mediation, my lord. I have instruction that there may be possibility of settling the matter. Subject to what they say, my lord.
You want to go from where to where?
Lordship, now she's pending in family court Guwahati, Lordship, and she is living in Shivsagar, Lordship. Therefore, she is praying for transfer to district court
Huh?
Shivsagar, Lordship.
Why you can't pursue here?
Lordship, she has no income source and the distance is so much, Lordship, around 365 kilometers. And she is living with her aged parents, Lordship.
Her brother is, I've not given my response here. Her brother is an advocate practicing here.
No, in these type of matters, I don't require.
Hello.
Tell me.
No, that's why I'm saying, my lord, timing, it may be stayed, it goes to mediation, my lord. Because my instruction is that my client is ready for some settlement, my lord. That can be tried here. So meantime, it may be stayed, my lord. They are asking for, I have no objection to that.
There is nothing to do. This has to go on the next day itself. What objection you have? You have filed this case here. Does she have any source of income?
No, possibly.
Transferred. Go on 23rd.
Well, I will be allowed to file a response, my lord.
Not necessary.
My lord, 7 days time, my lord.
No. On 23rd, okay, give you a date on 1st of July, 2025. Before the district judge, which one?
Sipsagar.
Sipsagar. You file your written statement.
29.
Mr. Chakravarti, these are matters which needs to be finished up immediately, these transfer matters. And I have seen transfer matters pending when I joined out here as a judge for 6 years, 7 years. And just getting a stay out here, it is going on. Now things have, that these matters, first question is whether she is in a position to pay. It doesn't matter over. It has to go there. And you see, here, you have to understand one thing. She has to come every day here.
I understand that, man. That's why.
Because it is the principal family judge. Here, lawyers are not there. There, you may engage some lawyer also. Okay. Yes, Mr. Mahmood. Item number?
Item 29.
29.
My lord, we are appearing for the respondents, my lord.
What is the matter about?
My lord, there is no degree and there is no execution. There is no degree. And the dismissal of the degree has been put into execution and we have been evicted.
Then
we file an application under 47. So that is running. So that is the whole entire episode. In 2015, my lord, this application was filed. And it's now 25. We are still fighting for possession.
I passed a long order in this matter.
My lord.
What is the result? Me passing a long order means he says that there is no decree.
Absolutely. No. He is the defendant, my lord. My suit was dismissed. I was in possession of the property. Subsequently, after dismissal, he files an application for execution. I don't know how. Then I'm evicted. After eviction, I come up under 47.
How?
That is the question, my lord. How am I evicted? They filed an execution on a dismissal degree. The court straight away issued a notice to the bailiff. I am evicted.
My lord, first thing, my learned friend is not saying the actual things. First thing is there is a title suit. That was filed by them. That title suit was dismissed. Then they filed an appeal before the learned additional district judge at Jorhat. That appeal was dismissed. Then they prepared an CRP before the Honorable High Court. And High Court remanded the matter to take a fresh decision by the district judge. And then matter was had dismissed the petition, which was filed by them. The appeal was also dismissed. Thereafter, for a long time, they did not file any appeal against the order of the additional district judge Jorhat before the Honorable High Court. No appeal was filed. The order became its finality. Then after that, my lord, a petition was filed that during the pendency of the bill, he said that I have purchased this plot of land from one Nasim Ali Hazarika. Now, Nasim Ali Hazarika was made a party initially, but later on, due to unknown reason, his name was struck off. So, cell deed did not prove. The court has found that cell deed did not prove. If cell deed is not proved, he has no land at all. He is saying that I have been evicted. Where is his land? Because his claim is that I have purchased this plot of land from Nasim Ali Hazarika. Nasim Ali Hazarika did not come.
No. First, where is the question of execution?
Well, execution was not necessary, but that was filed.
No. Who filed the execution?
It was filed by the present petitioner.
Okay. Now, was there any decree passed? Execution done.
Nothing was execution, or execution means, that means he was not in possession. Automatically, the land was there, that was given.
By whom?
That was given by the registrar of the.
How?
How means, my lord, they have no land, but.
No,
what
no,
is his
first,
locus?
what business does the court have to do?
The
Thank goodness,
court-
what is wrong?
No, court has to do, they don't, because they have no case. How, what is their locus? First
No,
lo-
forget about that. I am not on their locus. First of all, where is the decree?
The decree is not, order is there, but decree.
But how did the learned executing court execute it?
No, decree was prepared by the appellate court, I think appellate court's order.
Show me.
Let me show the appellate court's order. Yes, 43, my lord. Now, last portion, page 59.
Page 43, no, page 42. In the result, the suit is dismissed.
Yes,
Then-
their suit was dismissed.
Then, where is the decree?
A lot of the fact remains that there is no degree. We have been.
Let me step.
According the appeal is dismissed.
Page 63, my lord.
Where is the execution application? Let us see.
My lord, I have it.
You have it?
My lord, kindly see page 68.
Now show me that execution application on the basis, because this is strict. If this is necessary, we will pass an order for immediately giving it back. Court had no business of. Appeal against the AI in the death of so and so. By letter dated demand does not arise so and so to issue notice to the judgment debtor plaintiff to vacate the part of the land measuring so and so. Mr. Sahiwala will call for the records.
My lord.
Let it remain, we'll call for the records. And if, I'm telling you, if this is being done by any court without a decree, then we should exercise the powers under 227 and do it right and give you back the possession if you have been evicted.
Grateful,
This is a serious thing which is happening.
grateful.
We can't allow this thing to happen.
Page 65 is the appellate court's order.
I've looked into
Decree.
that, all are suit dismissed, appeal dismissed. Where is the
Yes.
decree?
So where is his land?
Then how can you go for an execution?
Yes, that was not necessary. That was not.
Because
necessary.
if I remember,
Yes.
when you made the submission before me on that date for
Yes.
which I passed this long order,
Yes.
that they are proceeding with an execution in a matter where there is no decree. That is your submission.
No, that
Yes.
is, they said that we will not adduce any evidence.
The coordinate bench has set aside the order and further made and observed that when the judgment debtor has refused to examine himself as a witness for proving the
They-
court should
Maybe
have
our case on
held that the
they will
allegation
not
raised
adduce
in the
any evidence.
petition and the learned counsel for the further submission the coordinate of this has also remarked that the learned executing court was unnecessarily proceeding further in the matter by wasting judicial time. The learned counsel for the Alimony so and so, the learned counsel for the visual submitted that the observations of the learned was completely in conflict with the order passed by the learned coordinate. He further submitted that the manner in which the learned executed. Mr. Mohammed, I'm telling you, if what Mr. Sahewala is saying is true, I am going to not only dismiss your petition, this one, I'll exercise 227, direct the registry and direct the executing court to exercise 144 and reverse the matter. Telling you, this is not,
But my lord, one thing is this,
no,
they have no land at all.
whether they have land
I
or not.
understand.
Mr.
That
Mr.
was-
Mahmood, it is not the question. Here, the executing court had to exercise the jurisdiction which is not there.
Not
It is
there.
inconceivable. And if the learned judge who have done it has, I think, this, have seen the law, I would not say have learned the law, have seen the law also would have known that without a decree, there cannot be an execution.
Decree was there from the
This the
appellate.
matter.
Appellate court, that is the decree. There is a decree.
Heard Mr. A.K. Sahewala, the learned counsel, appearing on behalf of
All the rest.
all the respondents. Mr. A.K. Sahawala, the submission so made by Mr. A.K. Sahawala appearing on behalf of the respondent shocks this court in as much as what is being submitted is that the learned executing court, that is the learned court of the Munsif Titawar, had executed a decree, had proceeded with an execution in title execution case number 6/2014. That too when there is no decree of any court. The learned counsel submitted that on the basis thereof, the petitioners, the respondents have been evicted, and it is under such circumstances an application has been filed under section 47, which is presently pending, and against which certain directions were passed for which the present proceedings have been filed. Full stop. It is the opinion of the court that if there is an execution being carried out by the executing court, that too when there is no decree of the court, it is on the face of it without jurisdiction. Full stop. This court being a court under Article 2 to 7 of the Constitution, this court having the jurisdiction, supervisory jurisdiction in the manner, is required therefore to set it right if the action on the part of the executing court had resulted in the petitioner, the respondents herein being evicted, that too without a decree. Full stop. Under such circumstances, for a further clearer picture of the matter, this court directs the registry to call for the records of title execution case number 6/2014. 14. Full stop. Taking into account that the matter has been fairly heard, list this matter on 24th of June 2025 at 2 p.m. The registry shall ensure that the records of title execution case number 6/2014 pending before the court of the learned Munsif Civil Judge, Civil Judge Junior Division number 1.
No, only one, Titawar one. Only
Civil
one.
Judge
But,
Junior
my
Division
lord, one thing
Titawar
may be observed,
is placed before this
in
court.
the appellate court, there was decree.
There is no decree.
Yes.
Right,
Can you see
show me.
that 63?
Page
63,
63.
yes. Para 68.
Yes. Para?
Prepare an appellate decree accordingly.
Dismissal degree.
Mr. Mahmood, you are pretty senior in civil law. Don't make that submission. Absolutely don't make these type of submissions. When we dismiss an appeal also, we say that the decree has to be prepared because there has to be a merger. So
Yes,
this is no decree.
dismissal-
A dismissal of a suit is also a decree.
Also a decree, I understand. But here is decree by the appellate court.
What is the previous paragraphs? Like, look, accordingly, this appeal is dismissed with cost and the judgment and decree passed by the so-and-so is affirmed. The suit stands dismissed. And you are saying that they prepare a decree? My goodness.
Here suit is dismissed.
Madam.
Understood. Then on what basis can a court decree and execute?
That is.
Never heard of.
The word is there, that is why, my lord.
Oh, Mr.
That was-
Counsel, I'm telling you, I'll take it up on that day. I'll put it, they will put it as part of.
And my lord, on that day, when
I'm going to restore the possession. This needs to be
restore the
done.
person, there is no man at all.
Where, what if the court have done this? Site of consolation. Next.
30.
In this case, my lord, in respect of respondent 1 and 2, we have to make test, my lord, that usual process, my lord, was not taken, my lord. In this,
What are you challenging?
challenging, my lord, the impugned order dated 18/12/2024, whereby, my lord, the application for allowing to file the.
For vacating the ex parte order by which condemn the Julian. Service not complete? What is the stage of the suit?
That is, evidence will start, it is not started.
So heard, Mr.
Be broadcast.
P.
Broadcast.
T. Purcaster.
Be broadcast.
B. Purcaster, the learned counsel appearing on behalf of the petitioner. Full stop. It is seen that the service upon the respondents have not been complete. Full stop. The learned counsel appearing on behalf of the petitioner submits that if no interim orders is being passed, it would result in the suit being proceeded with to a stage and thereby would lead to an irretrievable situation. Full stop. This court fixes the matter again on 18th of June 2025. The petitioner is directed to effect service upon the respondent numbers
1 and
1 and 2 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. Full stop. Till the next date, this court further stays the further proceedings of title suit number 706/2021 pending before the court of the learned civil judge, junior division number 4, Kachar at Silchar.
Obliged.
Take steps, otherwise I'm going to vacate it.
31,
Yes, what is this? They have appeared, I've taken the step.
We have appeared into it for both the respondents.
For justice service. So it is complete. 1 and 2.
Both the- For both the principal respondents.
Yes, your written objection was not taken on record with the cause. What is there?
Thing is, whether they can file this petition or not. Their petition was, one petition was rejected. Against them, they have filed a petition for review.
What?
Review, barred by limitation, barred by limitation.
Mr.
Now-
Mr. Sharma, kindly appreciate one.
A review was filed barred by limitation.
See, I know one thing that you are a civil lawyer, you know that. In civil proceedings, you always have small battles. Take this as a battle and fight the war. Let him file his objection and then proceed.
Other matters in there. For since 2021, he's filing similar petition. Already they have just prepared a petition, they are filing similar petitions. So what the court will do? What the court will do?
What petition they have filed?
They are filed similar petitions.
No, here is the case of filing objection.
Objection against the execution.
So,
Yeah.
so they want to file an
They are
objection.
filing a similar objection, he filed a similar adjournment petition.
Huh?
Page no 52.
But where is the decision passed? Where is the decision taken? There have been many petitions, I understand. The question is therefore, we need an urgent solution to the execution proceedings. Let them file their objection and then I'll direct the executing court to dispose of as early as possible.
That is why I probably since 21 he is filing similar petition that I could not
I-
get the certified copies.
No, it's okay. Let him, he says that he will file his objection. You are going to file the objection? 7 days? File the objection.
Will you receive allow the 25/11 the order was passed and the review petition was filed on April 25.
All understood, but the question is filing of the objection, if I don't allow it, what happens? That, you see, my basic idea out here is allow those things which can be done on merit and finish it off. But once the merit is decided, you have to take it up very well. But these small matters should not be basis on which.
They have filed the objection also. Objection is also enacted with Madam.
They filed objection earlier.
Here they have submitted the objection. Madam. What is that objection?
No, this is the objection, na?
On merit of.
Page annexure 8.
It is also on merit of the case.
Understood. They will let the executing court decide. Let this annexure 8 be taken on record and the learned executing court now too has to decide within 6 months. We'll decide and finish it. Why I stayed on the last occasion is there's a reason. Now with, you see, with the Supreme Court judgment which have been passed, one is to complete of the execution proceedings with immediate effect. Now, if I don't stay there, then the presiding officer is put to blame. One has to take note of that. So we allow him, kindly take this and let the executive court decide.
What about the delay? Since last 4 years, they are taking time. That delay they have committed. That delay they have committed in filing just a petition. Madam.
At a cost of 15,000. And you will appear on this date, huh? Next date is, there's a stay was there, na? Is there any date fixed? 6th of June. Okay. So they let that be taken and the court will hear the matter and pass off appropriate order. Huh? Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. And Mr. A.J. Sharma, who appears on behalf of all the respondents. Respondent number 1 and 2.
Respondent 1 and 2.
Right. This is an app that the jurisdiction, the supervisory jurisdiction of this court has been invoked, challenging the order dated
5/11/2024 and 4/3/2025. Two orders.
25
25/11/2024
and
4/3/2025.
4/3/2025, whereby the petitioners who are the judgment debtors have been debarred from filing the written objection. Full stop. This court have duly taken note of the materials on record and further that the objection have objection to the application filed seeking written statement seeking execution have already been filed before the learned trial court, executing court. You have filed that annexure 8?
Filed, but it was not taken on record.
But not taken on, was filed before the learned trial court, but was not taken on record. Full stop. Taking into account the materials on record, it is therefore the opinion of this court that the learned trial court, learned executing court, that is the court of the civil judge junior division number 4 Kamrup Metro at Guwahati, shall take on record the written objection which is annexure 8 to the present proceedings, and thereupon decide the said execution application being title execution case number 5/2020 at the earliest. Full stop. This court further duly takes note of that there has been certain delays and latches on the part of the petitioners which have resulted in the delay in the execution proceedings. Under such circumstances, this court imposes a cost of rupees 15,000 upon the petitioners, who are the judgment debtors in title execution case number 5/2020. Full stop. The said amount of rupees 15,000 shall be deposited by the petitioners the judgment debtors before the learned executing court on the next date so fixed hereinafter. Full stop. Taking into account that both the parties are duly represented, the interim order passed on 28/4/2025 is vacated, and the parties are directed to appear before the learned executing court on 9th of
6th of June.
On 6th of June 2025. So on the said date, the petitioners prior to the said date, the petitioners shall file the written objection, which is annexure 8 to the instant proceedings, and the learned trial court on the production of a certified copy of the instant order shall duly take it on record. Full stop. Along with filing of the said written objection, comma, the amount of 15,000 shall also be deposited. Full stop. The deposit of rupees 15,000 shall be a condition precedent for acceptance of the written objection. Next. The learned trial court, the executing court thereupon shall decide the execution proceedings. Shall duly hear the execution proceedings, taking into account the business of its court, and preferably, and complete the same preferably within 2 months, taking into account that the execution proceedings have been pending since 2020.
May be allowed to,
The decree holders would be at liberty to file application for release of the amount of the cost, release of the amount, which shall be, and the learned trial court shall pass appropriate orders.
Much of.
32.
Service not complete.
Complete. An application has been filed for withdrawal the deposit I have made. The claimant has filed an application for withdrawal of the deposit that I have made.
This is an application filed by the claimants.
Yes, Your Lordship.
Who are the respondent numbers?
Respondent number 1, appearing for the claimant, respondent number 1.
Who is the respondent number 1 to the accompanying appeal? Pusto. Seeking direction from this court for release of the amount of rupees 4,75,495, which was deposited by the appellant insurance company pursuant to the order passed by this court on 16/12/2024. Pusto. This court has taking into this court, upon hearing both the parties, is of the opinion that appropriate directions are required to be passed for release of the amount of rupees 4,75,495. Accordingly, this court directs the registry to release the said amount of rupees 4,75,495 to the applicant oblique the respondent number 1, applicant oblique the claimant, upon production of, upon making due verification, upon identification, verification, and on production of, on furnishing of the bank particulars. It is made clear that the registry shall only release the amount directly to the bank account of the claimant.
Service on respondent number 2, who is the owner of the vehicle, could not be served because they have shifted to Guwahati, not at the address. You have to go for a paper publication.
You want to take paper publication?
No, they've shifted to Guwahati. The original address was, that's the report.
How do you know Guwahati?
That's the report, I think, it's there in the list. Could not be served, shifted to Guwahati. That is the comment. It's in Vishwanath Sareli.
You inquire and then we take it up. Main petition Mr. R. Goswami, the learned counsel, submits that he would make necessary inquiry as regards the address of the respondent number 2 and then make appropriate submissions. List the matter again on 2nd of June 2025 for an update by Mr. R. Goswami.
Your Lordship, I will not be available on 2nd June.
You are not there. This day you will take the money, take over.
33.
You want release?
Yes, my lord.
Who is the other side?
Other side, my lord, you check the causes, my lord, their name has not been shown, my lord.
They are not the appellants.
They are the appellants. But mistakenly, my lord.
It has been disposed of.
Dispose of matter, my lord.
Appeal has been disposed of.
Dispose of, my lord.
Then?
After dispose of, my lord, the insurance company deposit the amount, my lord.
They've deposited.
They deposited, my lord.
So you want to take it?
We want to take it, my lord.
Okay.
Yes.
This is an application filed for release of the amount.
15,29,263, my lord. Paragraph two, my lord.
Release of the amount
Paragraph number two, my lord.
of rupees. How much?
Uh,
The release of the amounts so deposited by the appellant insurance company before the registry of this court pursuant to the order dated 19/3/2024 passed in MSC case number, MSC appeal number 138/2020. Full stop. Taking into account full stop, taking into account the judgment, the order passed on 19/3/2024 in MSC appeal number 138/2020, this court finds no ground to refuse the relief so sought for. Accordingly, the applicant or applicants?
Applicants.
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 Yes.
Applicants are given the liberty to, are given the liberty to file appropriate application before the registry of this court, and the registry shall, upon making due verification, after making due identification, verification, and on furnishing of the bank particulars, transfer the said amount to the applicant bracket FS.
Yes.
Full stop. It is made clear that the said amount shall only be transferred by way of bank transfer. I extend it.
34,
Yeah.
For
Uh,
release,
IA for condonation of delay.
how much?
My lord, 1760 days, my.
Huh?
1760 days, my lord.
Where's the other side?
Notice, this is the first day, my lord.
First date.
Yes, my lord, 1760 days.
Fellow, issue notice.
Yes, ma'am.
Second appeal.
Second appeal.
What is your ground?
Ground, my lord, basically, my lord, due to choice of wrong forum, my lord. Due to choice of wrong forum, basically.
Okay,
my lord.
issue notice. Notice koi ribo na prescription.
Highly obliged, my lord.
Yes, Mr. Goswami. I was just 3 minutes late.
Friend has made a calculation, I agree with you.
Today, a lot of MSc appeals have gone for a 6. Heard Mr. R. Goswami, the learned counsel appearing on behalf of the appellant insurance company. And Mr. A.K. Gupta, who appears on behalf of the respondent.
1 to 4, my lord, claimant.
Numbers 1 to 4. So stop. Taking into account that the grounds of objections were taken, the instant appeal is being taken up for disposal at the stage of Order 41, Rule 11 of the Code of Civil Procedure 1908.
Admission.
Huh?
Admission, this is MSc appeal.
Present appeal. What is there?
The lordship says order 41, my lord, this is under admission column.
Under?
Admission, this has come for admission.
How do you admit it?
No, I'm not saying.
Huh?
The lordship says order 41, my lord.
Yes. The appeal has to be admitted under Order 41, Rule 11. Meaning thereby, this the date is fixed for hearing. We looked into the provision. Take it up. Under Order 41, Rule 11 of the Code. The present appeal is directed against the judgment and award dated 26/2024 passed in MSc case number 14/2017, whereby an amount of rupees 26,89,000 have been awarded as the compensation. And further, the appellant insurance company have been directed to pay interest at the rate of 9% from the date of filing of the case till realization. Full stop. The grounds of objection so taken by the learned counsel appearing on behalf of the appellant is that the learned first tribunal have wrongly applied the judgment of the Supreme Court in the case of National Insurance Company Limited versus Pranoy Sethi and others, reported in 2017-16 at 6680 in respect to future prospects, and granted future prospect at the rate of 50%, which ought to have been 40%. The learned counsel further submitted that in respect to as the accident occurred prior to the judgment passed by the Supreme Court in the case of Pranoy Sethi Supra, the compensation which could have been awarded on account of funeral expenses, loss of estate, as well as loss of consortium should have been 15,000, 40,000, and 15,000. Funeral expenses hole 15,000, loss of estate hole 15,000, and 40,000. The learned counsel for the appellant further submits that taking into account the judgment of the Supreme Court in the case of Magma Insurance Company versus so and so 2018 so and so all the claimants would be entitled to on account of spousal na? Spousal
Spousal as well as parental.
and parental and filial.
Yes,
Be entitled for loss of consortium on account of spousal, parental as well as filial. And therefore, the loss of consortium should have been 1,60,000 and not 1,76,000. The learned counsel appearing on behalf of the appellant further submitted that the loss of love and affection of rupees 50,000 could not have been added in view of the judgment of the Supreme Court in the case of Pranoy Sethi. Further to that, the learned counsel appearing on behalf of the appellant further submitted that the rate of interest at 9% was very high, taking into account that was very high, was excessive, and without assigning due reasons. Full stop. Mr. A.K. Gupta, the learned counsel who appears on behalf of the respondent, submitted that appearing on behalf of the respondent numbers 1 to 4 had submitted that you agree. We go on an agreement then. Submitted that taking into account the judgment in the case of Pranoy Sethi, the petitioner's entitlement would have been 40% on account of future prospects. And further, the funeral expenses, loss of consortium, and loss of estate should have been rupees 15,000, 1,60,000, and 15,000. He further submits that the claimants have no objection in respect to the interest at rupees 7.5% from the date of filing of the case. Taking into account the respective submissions, this court have the respective submissions, and the agreement and the consensus arrived at by the learned counsel amongst the learned counsels appearing on behalf of the parties, the modified award. This court modifies the judgment and award dated 26/2024 with the following amount: loss of dependency, rupees 16,20,000; loss of future prospects, bracket 40%, rupees 6,48,000; funeral expenses, rupees 15,000; loss of consortium, 40,000 into 4 is equals to 1,60,000; loss of estate, 15,000. Total 24,58,000. Full stop. This court further observes that the petitioner herein, the claimants herein shall be entitled to interest at the rate of 7.5% on the amount of rupees
Let's say 50% of the awarded amount has already been deposited in Shukla also. 50% of the awarded amount has already been deposited in.
No, on future prospects, you have no problem. Interest?
No, that may not be allowed, Lordship, since High Court is not allowing it.
Huh?
Since the court, High Court is not allowing future interest on future prospects.
So that is what I'm saying. The interest of at 7.5% per annum shall be payable with effect from the date of filing of the claim proceedings on the amount of 16 lakhs 20,000 plus
18 lakh 10,000.
on 18 lakhs 10,000. There shall be no interest on future prospects, that is on rupees 6 lakhs 48,000. Next. It has been duly informed by Mr. R. Goswami that the learned counsel that 50% of the amount have already been deposited where?
In the Shukla, Lordship.
Before the learned tribunal. The remaining amount, 50% of the
Awarded amount has been deposited.
without interest.
Without.
Of the awarded amount without interest have been deposited before the learned tribunal. The remaining amount as adjudged herein above shall be deposited within 2 weeks. Within 2 weeks from the date of the present order. This court further observes and directs that upon such deposit being made, the learned tribunal shall disburse the said amount, but in doing so shall duly take care that the said amount is disbursed to the bank accounts of the claimants through
Any
NEFT, RTGS,
friend.
IMPS. Oblique NEFT, RTGS, IMPS. Or through electronic mode.
I just paying for one line, Lordship, that I had contested a ground contributing negligence, it has been not considered for. That it was my main ground was contributing negligence. I had not laid any evidence. So it is rightly dismissed that part of the.
তাৰ ওপৰত এটা লাইন লিখি দিব এই গোটেইখিনি সাবমিশন তেখেতৰ হোৱাৰ পিছত তাৰ আগতে লিখিব Mr. Al-Gusami further submitted that the learned tribunal had also erred in law in settling the entire liability upon the appellant insurance company without taking into account the question of contributory negligence. At the outset, it is relevant to take note of that the question of contributory negligence can only be raised if there are pleadings and proof to that effect. There being absence of pleading as well as proof, on behalf of the appellant insurance company, the question of contributory negligence does not arise. আৰু এই তাৰ তলত এটা লাষ্টৰ লাইন এটা লগাই দিব that the learned tribunal upon deposit of the amounts so directed herein above before the learned tribunal and an order being produced before the registry, as regards the said deposit, the registry shall refund the amount of rupees 25,000 to the appellant.
Statutory deposit. Statutory refund of statutory deposit.
I said that.
So the total amount that has been paid, if it is required to mention, it can mention 13 lakhs 44,500 has been deposited.
13 lakhs
44,500.
Itu demo kolo only 50% has been of the year without interest বুলি কৈছে ন সেইটো amount of rupees so and so have been
13 lakhs 44,500. Obliged.